Hmm. Your wife is no more. So this has become infectious, right? What is the date of death at least? You are Mr. Bhatia. Um, Item 93, Sri RKG Bhatia, Land Counsel for Appellant. On instructions would submit that the appellate has been preferred and will challenging the order passed by the family court in open number so and so, dated so and so. Family court of Hyderabad seeking over to the filed by him seeking dissolution of marriage against respondent wife, respondent wife died on 14/7/2021, and therefore nothing remains in the present of the it has become effective, therefore dismissed the case. Okay. I remember 53 years. I have become infectious. The respondent wife has I have become infectious. Why? You are representing Mr. Pawan. Yes. What is the date of death? What's your name? Mr. Jagadishwar, Land Council representing Mr. Pawan, Pawan Kumar. Land Council for appellant on inspections will submit that respondent wife is number. Therefore, nothing remains in the present appeal to adjudicate further. It has become infectious. Therefore, dismissed as infection. Any other mention? No. Online law. No? Husband's property.
Yes, I have filed a divorce petition that is being allowed.
Wife is not interested. Why? What is the date of the order? June.
June,
Cruelty as well as desertion. Cruelty as well as desertion. On both grounds, she filed a right? What is the date of marriage? 2007.
Date of marriage is 2007.
How many children they have?
Only one son belongs, and she left the matrimonial house in the year 2008, except the lordships prior to delivery. During her pregnancy, she left the matrimonial house in the year 2008.
Notice to respondent, person of the department, and council declaration of involved the department. Serve notice on the council approval for respondent in open number 6, development of continue. Selling on favor, please.
A victim of
This last
a life convict.
dispense with order, you admit.
Meantime, you call for the records and book me ready.
This on 6th
And,
March. 6th
and-
March.
Yes, you lot. So other two matters were filed A1 and A3.
Give the number.
Posted on 7 to lot.
7 2.
February.
Give the numbers.
Yes, sir.
Along with so and so.
I will provide.
7 2. Yes.
Much of
Lord, I represent Marishankar. Criminal appeal filed, my lord. Aggrieved by the judgment of special judge.
The sole accused.
Yes, my lord.
Then we'll admit the appeal.
Yes,
Admit registration counsel. List on 8th January.
obligement.
A1 subject. Other, A3 supple is posted to yesterday, A3 supple. A2 supple is posted to? Yesterday's matter is posted to which date? You don't, you admit. Please special call for the record, list along with songs. Yes. In a matter of the item. What is this following mentioned application?
Lordship, in this matter, a small clarification, Lordship. OP 295 of 16 is filed by the wife, Lordship, for the dissolution of marriage, and which is allowed by the lower court with a common order. The husband has filed for the dissolution of marriage, and it has been allowed, Lordship, for the with a permanent alimony by granting 50 lakhs, Lordship. So, but the Lordship has granted interim suspension, Lordship, in which the payment of the permanent alimony has been also stayed, Lordship.
Why the impugned order dated so and so? Resolve the marriage of the so and so. Currently operating respondents may be married during several years. Therefore, there shall be interim suspension of impugned order dated 295. What is the problem?
That order is given in the lower court for the payment of the permanent alimony, Lordship.
295 filed by whom?
295 is filed by the husband, Lordship,
What is the relief sought?
for the resolution of marriage, Lordship.
That was allowed.
Yes, Lordship, but the common order, Lordship, 2 FCS are filed, Lordship.
2 FCS.
Yes, Lordship.
295 is for restitution of
Conjugal rights.
680 is for divorce.
Yes, Lordship.
So divorce application was allowed,
No.
right?
Yes, Lordship.
Filed by husband.
Hus-
Wife. And who is the, no, 1 second. Who filed 296, 295 of 2016? Wife filed.
Wife filed the 295
So that was allowed.
yes, Lordship,
680 by the
by
husband
the husband.
seeking dissolution.
Yes, Lordship.
What?
For resolution that was also allowed, Lordship, in which
Madam, who filed 295 of 2016? Wife
Yes.
filed.
I may, but
1 second. Wife filed 295 of 2016.
yes,
What
Lordship,
is the relief sought in 295?
for the restitution of the conjugal rights, Lordship.
What happened to that application?
That application has been allowed, Lordship,
Allowed.
allowed.
Then who filed 680? Husband filed.
Husband filed
What is the relief sought?
for the dissolution of the marriage,
What
Lordship.
happened to that OP?
That OP has been allowed, Lordship.
రెండు అలో ఎట్లా అవుతుంది? రెండు అలో ఎలాగైతే చెప్పండి. మీరు కన్ఫ్యూజ్ నన్ను కన్ఫ్యూజ్ చేస్తారు. ఇప్పుడు చెప్పండి మీరు.
ಇಲ್ಲ.
లేదు మరి
295 of 2016 filed by the wife for issuation of conjugal rights, which is been dismissed.
అది
The other application filed by the
ఫర్బింగ్ మెన్షన్ కూడా
I
కన్ఫ్యూజ్
apologize.
చేస్తే ఎట్లా?
I apologize.
మేము లేదు మొత్తం చదువుకొని రావాలి ఇంటి దగ్గర. ఎక్కడైతే చెప్పండి.
I
ఇట్ ఇస్
apologize.
నాట్ పాసిబుల్. వేర్ ఆల్సో హ్యూమన్ బీయింగ్స్.
the other application filed by the husband.
680 was
Yes, that was allowed. Common order passed.
Wife filed appeal.
Wife filed appeal
Challenging 680.
challenging both the OPs, challenging both the OPs.
Both ఎట్లే సార్ ఒక సింగిల్ అపీల్.
Two
అదర్ అపీల్.
the other appeal is suspended.
680 సస్పెండ్.
Yes, suspended.
295 of
295, wherein this honorable court by orders dated 20th of June 2023 passed interim orders by suspending the order in the OP also.
It is dismissal order. What is that they'll get if you suspend? ఏంటండి ఇది చదువుకోవాలి కదా.
Lordship, short pass.
Distribution 295 2016 was dismissed. So you are seeking suspension of order which was dismissed. కదా.
Short pass, Lordship. I'll get back. Lordship, short pass, Lordship. I'll get back with it.
నాకు క్లారిటీ వచ్చేసింది. మీరే క్లారిటీగా లేరు.
Short pass, I'll get.
సో we will call this matter at 1:30. షార్ట్ ఉండదు ఇంకా. రికార్డ్ వచ్చింది. Yes, Mr. Rashekar.
Please, minute, I apologize for the non-appearance of the last occasion. May I request for the next week?
No, This is already in the dismissal. 2012 appeal, why you are seeking time, Mr. Rashekar, tell us?
My lord, in the last section, is continuous appeal will last only longest one occasion. The day, it may be posted day after tomorrow.
2008 OP, 2012 FCA, and you are
Yes,
asking time simply. What to do, tell us?
My lord, today I'm station I'm presenting with somebody else.
Earlier
By
also
tomorrow,
this appeal was, 1 second. Earlier also we have listed this appeal in the caption for dismissal. On your request, we have removed it. Even then you are asking time. What to do, tell us? At request of land council for appellant, list on. Either way, we will go through the record, we will pass orders.
Definitely, definitely.
Appearing for the appellant, Your Honor. This appeal is being filed, executed by the order of the FCOP 538 of 2008.
Who filed OP? Husband,
Yes, Your Honor.
seeking dissolution of marriage. What happened to that OP? That was dismissed.
It was dismissed, Your Honor.
So cruelty and desertion both. Is it not?
Yes, sir.
Cruelty, desertion. You have examined only one witness, that is yourself. How
Yes,
many
sir.
documents you have filed? What is this FAOP 112? Pradeep?
That was,
Earlier, the husband has filed similar OP for dissolution of the marriage, cruelty and decision that got dismissed.
That was dismissed. Dismissed, and what is the date of this order? P3?
That is expected
Exhibit P3.
P3, mother.
P3, 21/10/2005.
5.
Is it not?
Yes, my lord, against which appeal has been also been filed before this
What
court.
is FCA number?
But last FCSR, my lord, last time FC, it was in FCSR with a delay.
It is still pending.
It was dismissed. I have passed on the order, my lord, last occasion.
It is there, Mr.
Pending this.
FCSR number 50864.
Yes.
So that was dismissed on 31st March 2009.
Right.
So during pendence of appeal,
He filed OP.
he filed 546 of 2000.
Initially 358 of 2007, again it is renumbered as
358 of
2007 one.
renumbered as 546.
Yes.
Then MC, what happened to this MC 70 of 2006? 5/5.
MC, she was,
MC
He was
70.
settling for the Lok Adalat, my lord, granting 4,000 rupees maintenance
to herself and,
You will hear him. 4,000 rupees per month.
per month.
So,
So the wife and the husband,
Whether he's paying this amount,
he has defaulted from last 2 years.
you have to file 125(3)
That is,
application.
the wife has not taken it.
Then what is this 401 of 2004 CC order?
But
Exhibit
498A, my lord, that was been
What happened to this complaint?
complaint, thereafter it was quashed.
Quashed or appeal?
Quashed.
Criminal petition number, they have to give in fact.
Yes.
Quashed. Then what is this P6? CC of order of special mobile court, Kakinada.
That is with regard to, my lord,
Yes, madam. What, according to what are the cruel acts by the wife?
she has filed a partition suit against properties which
What is the OS number?
OS number 443 of 2000.
Children?
one son.
One son. What is the age now? Date of birth, the age?
His date of birth is 2003, my lord, 26/12/2003.
26/12.
2003 was his date of
Almost 20 years.
20 years now.
Who filed suit? Wife or son?
Wife,
What is the OS number?
436 of 2016 Lordship.
2016.
16. That material has been not filed before the honorable court. That material has not been,
So filing partition suit is cruel act according to you.
no, not only on behalf of the, on against the
We are
husband.
hearing on merits.
Not 2016, Malad is what?
It is not there. We have seen pleadings, it is not there.
Not again as a husband, but
Madam, duties of 2016,
yes,
yes or no?
yes.
Then first OP is of 2005, second OP is of 2007. This we will not consider. Next. Next
And-
Cruel Act.
And she has filed a DVC in spite of taking maintenance.
Maintenance 498 Cruel Acts కావండి.
No,
ఇంకా చెప్పండి.
no, sir. My submission is that she has taken maintenance,
MC 2006.
and after taking of the maintenance,
98 ఒకటి నాకు list of course before filing of 114.
after taking of the maintenance, she has filed a DVC before Nampally Court, Your Honor.
DVC కూడా ఫైల్.
Yes, Your
What is the DVC number?
DVC number, not having a present material, Your Honor. 2 weeks time may be given. I'll file along with the
We are deciding today, right now.
Lordship, I'll file.
2011, second. First OP is of 2005, second OP of 2007. Appeal is of 2011. And you are asking time, what is the message we are sending to a common man? We are deciding right now. So DVC file, what happened to the DVC?
DVC, she is receiving amounts of 20,000 odd towards maintenance.
Next.
And till now, he has paid more than 24 lakhs above.
What happened to this partition suit?
Partition, it got dismissed as the
Dismissed.
property.
Hmm.
And she has preferred an appeal on that and it is pending.
Appeal is pending.
CCA 103 of 2023.
CCCA?
103,
Hmm.
2023.
Next.
And
These are the cruel acts. Now, what about desertion? What is the date of desertion according to you?
desertion is from the year 2003, Your Lordship.
What is the evidence you have produced?
Till now, she did not file any application before any court.
You have to file RCR. You have to file section 9 application seeking restitution. If your wife is not coming to you and you have a son 20 years old. So instead of filing the restitution of conjugal rights petition, you have filed divorce application twice, not once.
Yes, Lordship.
That's all? Yes, Mr. Sudeep. No cruel act, right? No desertion,
No decision.
no proof. And he examined himself. What about first OP? How many witnesses he has examined in the first OP? Maybe one.
70. Page number 70 is the order.
70?
Only 1 month.
Only
Page
one
number
month.
78.
70?
Only one. And the last. The court said for
Hmm, same.
there is no desertion.
Radha Krishna Veni Sudarshan.
Yes.
What's your నిన్న ఆర్టీ వాళ్ళు డిస్మిస్ 2:30 we are not sitting. You are aware special bench is there. Tuesday. Item 8 at request of Srikanth CH Land Council for appellant list on Tuesday. Anyway, GP completed for his reply.
That day we will also file, our written arguments. If they also want to file.
File?
Written arguments.
You want to file written argument? File it.
Written argument on the same day. If at all, GP also requires.
All file చేయాలి శ్రీకాంత్ వాళ్ళు ఎందుకు ఫైల్ చేయమంటారు
If at all they want to file, I'll just.
అది ఎందుకు అవన్నీ వాళ్ళు ఏం చేస్తారు అనేది యూ హావ్ నథింగ్ టు డు రైట్ ఎస్ రెస్పాండెంట్ టు సెట్ అమ్మా ఏంటిది సెట్ అండ్ ఎక్స్పోర్ట్ ఏంటి మీరే ప్రాడక్ట్ సెట్ ఎక్స్పోర్ట్ ఎన్ ఎక్స్పోర్ట్ రిజిస్ట్రీ with regard to service of notice on respondent number 1 return to sender. Left to however to be one more person issue percentage లో first respondent person receive 500 ఉన్నాడండి వెంకటేష్ గుప్తా none of press for appellant proof of service in compliance with order dated 1/11/2013 sorry 23 is not filed. Released on 15th in the caption for this mission. Yes. Yes, Mr.
May I
Simon.
please, Lord? Yes, madam.
Hmm.
The petitioner is the appellant is the petitioner in the lower court. Filed OPM 253 of 2010
Ah,
for a decree of divorce under section 13(1)(1)(a)
on the
of
ground
Indian
of
Marriage Act.
cruelty. On the ground of cruelty.
On the ground of cruelty.
What happened to the OP dismissed?
That OP is dismissed.
She was set ex parte.
She was
What
set
are the cruel acts?
in spite of the same melody, the OP is dismissed.
No, the ex parte order should be on merits. You have to make out a case. Kada,
Yes.
that is
Yes,
the law.
yes.
How many
Yes.
witnesses you have examined to prove cruelty? Only one.
Only one witness. Only one witness.
The documents, ration card, invitation, marriage photo. 3 days డైవర్స్ ఇస్తారా భలే ఉన్నారండి
I leave it alone.
అలిగేషన్ ఏంటో తెలుసా ది టైం వన్ పర్సన్ వాజ్ మేక్ September 2000.
Item 11.
Unclaimed.
Claim.
Who filed OP?
But the marriage was on 17 to 2005.
Filed by husband
Husband,
seeking dissolution of marriage.
on the ground, my lord, that marriage was not consummated, she did not cooperate for consummation of marriage.
Cruelty.
That's
Cruelty.
correct.
That was dismissed. PW1 is the husband. PW2 Dubbala Sudhakar.
Yes, sir.
Who is it?
But their distant relative.
Distant relative.
That wife was examined in Lord's mechanism on two grounds. It was dismissed on the ground. The notice was given to her for restriction of conjugal rights. That she gave a reply. It's an admitted fact.
Argued jail.
It was not marked.
Panchayat resolution ఏంటి?
Panchayat resolution, they should leave amicably. In that Panchayat resolution, there was no reference about her frigidity or non-cooperation or consummation of marriage. And also, the exhibit B1, notice that there was no reference. B1,
లేదు P1 లేదు.
B1.
P1 అండర్టేకింగ్ నోటీస్ కాదు. ఈ స్కానింగ్ రిపోర్ట్ ఏంటి? B3.
Ultimately, she did not join the
B3 ఏంటి?
B3 is a sanction
ప్రిస్క్రిప్షన్ అండ్ స్కానింగ్ రిపోర్ట్ అంటున్నాను.
of the Panchayat resolution. On two grounds, it was dismissed. One is, my lord, that the petitioner failed to produce the notice given to her for restitution of conjugal rights. The other one is, my lord, that the petitioner, other ground is that the petitioner, in his examination, did not say that his personal knowledge about her fragility. He did not cooperate the fact, my lord. And she admitted, my lord, in her, my lord, examination that she received a notice and replied. A criminal case has been filed against her. He filed a criminal case, 498 for harassment. There is no reference about the registration of crime. The parties given the file, my lord, they did not respond to me. But fact remains is, to my on perusal of papers, that both are living separately.
Since
The 2005, my lord.
2005.
5 is a marriage.
B2 డిసిషన్ 19/4 కదా. తర్వాత 27/6 ఈ ప్రిస్క్రిప్షన్ స్కానింగ్ రిపోర్ట్ ఎట్సెట్రా. ఈ సిరీస్ డాక్యుమెంట్స్ ఇవ్వండి, RW1 ఎవిడెన్స్ ఇవ్వండి. తర్వాత ఇది కదా ప్రూఫ్ ఆఫ్ సర్వీస్ అన్క్లెయిమ్ వచ్చింది. ఇది అన్క్లెయిమ్ ప్రాసెస్ కోసం ఇంత ప్లాన్స్.
In the counter, she admitted, my lord, the receipt of notice.
Where is the counter?
Page 15, my lord, para 6, my lord. The real fact submitted by the respondent is that the petitioners got issued a legal notice through Ravi Kumar Advocate so and so for restoration of conjugal rights properly. Reply notice was issued to the respondent. Due to the subsequent development, the respondent temporarily dropped the intention of filing case for restitution of conjugal rights, and in view of the petitioner and his family members subjecting continuous physical and mental harassment, such circumstances drove the respondent to commit suicide. Great difficulties, she recovered herself from normal position.
Respondent attempted to commit suicide.
No, all the allegations do not indicate about the payment of additional dowry.
What happened? We are not on additional door. What happened to the CC 369 of 2008?
There was no response.
Acquitted. MC?
MC payment, maintenance is being paid. I understand payment is made.
She filed two MCs, two 125 applications.
Yes.
39 of 2007 as well as 31 of 2007. The documents and documents B1 to B3. హామీ పత్రం ఉందా మీ దగ్గర ఎగ్జిబిట్ B1 ఉందా? ఇద్దరిని కలపడానికి 19/6/2006 సోమవారం రోజున నివాసైన కళ్యాణి తండ్రి పెద్ద మనుషులు సంప్రదింపులు జరిపి పిదప భార్యాభర్తలైన కళ్యాణి ఇద్దరు ఇందుకు వీరి యొక్క సంసార జీవితంలో ఎలాంటి ఇబ్బందులు లేకుండా వారి ఇరువురు కొత్తగూడెంలో సుఖ సంతోషాలతో బాగా ఉండాలని లేరు ఇష్టానుసారం ముగ్గురు కొత్తగూడెంలో కళ్యాణికి ఎలాంటి ఇబ్బందులు ఎదురని కనీసం వీళ్ళనైనా ఎగ్జామిన్ చేసేది ఉండే కదా మేము ముగ్గురు నా ఒక్కరు కూడా ముగ్గురు
పెద్ద మనుషులు
మీడియేటర్స్ పెద్ద మనుషులు ముగ్గురు కాదు, ఐదుగురు అండి. కొట్టకపోతే ఏం చేస్తారు? పంచాయత్ తీర్మానం 19/4/2006 దీనికి కూడా 6 మంది ఉన్నారు. టచ్లో ఉన్నాడు అమ్మేవాడు
ఎవరు లేరు అసలు.
మరి ఇప్పుడు ఏం చేయాలి?
మెరిట్స్ డిస్పోజ్
మెరిట్ అంటే డిస్మిస్ అయ్యాయి. క్రూయల్ యాక్ట్స్ ఏం లేవు కదా.
ఓన్లీ
ఈ ప్రిస్క్రిప్షన్ ఏంటంటే ఇప్పుడు ఫ్రిజిడిటీ ఏంటి అసలు?
నాన్ కోఆపరేషన్ టు కన్సమేషన్ ఆఫ్ మ్యారేజ్ ఇస్ క్రూయాలిటీ.
కనీసం అదే అడగాలి కదా మీరు. క్రాస్ ఎగ్జామినేషన్ లేనే లేదు మీ కౌంటర్ పార్ట్ ఇన్ ఫ్యామిలీ కోర్ట్.
Acquittal
knowledge about frigidity and fear psychosis. I did not take respondent to the doctor. Oh, ఇది ఈయన క్రాస్ RW1 again. RW1 cross.
no, lots of kindly see.
PW1 cheap లో కూడా
Lawyer put a question to the party, Lord, what is the frigidity and Miller's fight? That he said that he has no knowledge. But
తెలిసినట్టు ఈయనకు తెలుసు కదా ఫస్ట్ లాయర్.
fact remains is that she did not cooperate.
కేస్ ఎట్లా కదా cheap లో.
Lord, she refused to receive the notice.
So and so. Enjoyment of several countries. Not interested in matrimonial bliss అన్నాడు ఒక వర్డ్ అంతే. Respondent due to rigidity and fear psychosis did not join in matrimonial relationship with me. Elders of both parties agreed for postponement of the no cause of paternity. Date of marriage, bro?
17/2/2005.
Almost 20 years.
Almost 20 years. Lord, the fact remains she refused to receive notice is sufficient, Lord, that she has now interest to lead marital life.
మీ కౌంటర్ పార్ట్ కొద్దిగా జాగ్రత్త చేసి ఫ్యామిలీ కోర్టులో సక్సీడ్ అయిపోతుంది. RW1 ఒక్కసారి ఇవ్వండి.
No, another aspect is, Lord, filing a false case also constitutes a cruelty, Lord. They gave a complaint, Lord, for about harassment on 498A. They failed to prove the case.
ఎంసీలు ఏమైనా కూడా చెప్తలేరు కదా మీరు.
MC amount. Maintenance cases, they pay, they order, Lord.
The observation of the family court is you have not mentioned in B1 and B2 undertaking as well as settlement with regard to that frigidity, etc. అది రాస్తే రిలేషన్ లేదు. It is true that petitioner got issued so and so.
Ready, about that words were not mentioned, but the fact is, Lakshman, fact is that
Are there. Therefore, panchayat.
yes,
On what are the dispute, they have not mentioned. the
Not,
details of the dispute.
non-cooperation for conservation.
Consider the word. Deposition is marked as exhibit A3. A deposition was shown to the witness. She admits her deposition. Endolo. Fifth amendment. Deposition is marked as exhibit A3. A3 living in this. There is no A3 at all. Adoppa Godamili. It is not true to suggest, so I'm saying. CC number, so and so it is marked as exhibit A4. A4, A3 ఉంది index లో లేదు. Appendix లో. ఈ appendix ఉన్నప్పుడు even B2 decision of panchayat dated so and so before our Sagara society elders. It is not true to say that in exhibit B2 indicate I refuse to join the society. It is not true. I have not joined the conjugal rights. The appendix. A4 CC judgment.
Go to acquittal of 490 case.
No document was reduced into running cross examination, CC lo. No document was reduced into writing with regard to dowry, presentation of gold. Raskuntra. We orally agreed 1 lakh rupees dowry, marriage of so and so, spend immediately after the marriage. Idi CC lo cross examination of wife. Immediately after the marriage, I followed accused number 1 to spend 3 nights as per our custom. Again, I returned to house and so and so. Only one question. It is not true. Like. It is not true. There are no. Not true. But I refuse to do so. It is not true to accuse you to come to me once in 10 days after the marriage and requested to come to cooperative. Him so and so sent me along with A1 saying that I am not keeping good health. Admission ఉందండి. I refuse to do so. Sorry, continuation. Stop. Continuation. Accused along with the elders came to my house. Witness said that my elders and elders are accused. Discussing the things that happened. But I refused. One more suggestion is there. During the course of adjournment, this court asked me to join accused number 1, but I refused. Sarpati? That's a permanent
Your Honor, I have to appellant. I'm requesting to kindly since my senior physiotherapy sessions. I'm appearing for in the matter, requesting to kindly have it on Friday, Your Honor.
What for? What for?
Well, it's for hearing, partly heard.
2011 appeal, madam.
Yes, Your Honor, genuinely, it's the first time I'm seeking a genuine. Last occasion, there was no representation. Traveling, my lords, I had requested my colleague to represent. I'm only asking for dating day after, my lords.
We will hear you on next Wednesday, but we will not grant you time.
Very well, Your Lordship. We'll ensure.
Request of Land Council for appellant, list on next Wednesday
Much obliged.
in the same caption. There is no representation. Third, Sri Praveen.
If it is the case, my lord, on submission, my lord. If it is the case, she has requested to grant a permanent alimony.
So we will hear him. Kishore is not there. We are listing matter next week in the caption for orders. We will hear him and then we will decide all three matters.
Next week on Tuesday, my lord.
Wednesday.
Wednesday, I may not be available.
Yes.
Okay.
Praveen, Land Council representing Mr. M.R.S. Remus, Land Council for Appellants in FC.
The post-COVID ailments also, my lord. Lordship may consider that and
Next Wednesday for orders.
oblige.
15th for orders.
Oblige, my lord.
Where is he now, husband?
Uh,
Presently.
she doesn't have any contact with them, my lord.
We'll ask him.
Yes.
What is the reasonable amount of permanent element according to him? That also, why don't you get instructions from your client?
By the next time, I'll.
Wednesday, next Wednesday.
Yes, my lord.
Asking to time, they send the notice, but it is written. Now they.
ఏం నోటీస్ ఏం నోటీస్
Just inform.
ట్రాన్స్ఫర్ నోటీస్ ఎవరికండి
Respondents, sir. Just
Yes.
inform them. Now they giving to the public.
who filed OP wife filed OP right 2-2-76 పాన్ బజార్ అయిపోయింది రాణిగంజ్ she filed wife null and void on the ground that her consent for the marriage obtained by using threat, criminal intimidation, etc. Husband filed OP. Next week for orders, right? At request of Land Council for Appellant, list on 7th, 15th. In the caption for orders. Refused. He claimed to refuse the attempt. చూడండి ఉందా ఎండార్స్మెంట్ నన్ను అఫేర్స్ ఫర్ అప్పలెట్ రికార్డ్ వచ్చింది list on 15th in the caption for us the name well register shall call for the record with the yes ఇవ్వండి reason for return of cover. In the cover, there is no endorsement at all. That is reason for return of cover. In the light of the film, and six time to file application seeking substitution. Appellant substitution application not filed based on 15th in the caption for dismissal. Yes.
It's around three, and water. Please also. But appellant in the case. Opinion number 367 of 2007.
Who filed OP?
The respondent clearly filed.
Why filed OP? Seeking?
Asking her lordship daughter-in-law filed OP.
Ah.
The section 19 of Hindu Adoptions and Maintenance Act of 1956 against the in-laws, father-in-law and the mother-in-law after the death of the suspect. Filed the OP of section 19. Hindu Adoptions and Maintenance Act with the in-laws.
So that was allowed. Directed, your clients were directed to return 2,95,000 with interest 6% and pay 1,000 rupees per month to petitioner towards maintenance. What is wrong with this order?
The petition was specifically filed in Section 19 of Adoption and Maintenance Act, but the relief sought in the petition was beyond the scope of Section 19 of Hindu Adoption and Maintenance Act. Your Lordship.
Do you have, one second, do you have act with you? Read section 19. Do you have act with you or not? Then how you are arguing? Hindu marriage, adoptions and maintenance. Right? Hindu కూడా పెట్టుకుంటే You don't have smartphone. No, then open it. We can't give hints to you, right? Either you have to come with statute or ఇంకా లేదు. Do you have 19, section 19? You are reading from? You have statute. Huh? Just now you said you don't have. Very good. Sorry. Read section 19.
Provided that to the extent she is unable to maintain where she has no property of her own, from the receipt of her husband or her father, from her son or daughter, or her estate, any obligation and tax shall not be enforceable. Father-in-law has not been means to do so for many purposes.
So maintenance she can claim. Return of article she can't. That will consider. One ground. Next ground.
The father-in-law is under no obligation when there is no purposeful property existed. The respondent established the purposeful property existed. But without considering the fact that non-existence of any purposeful property in the hands of the appellant parent.
What is exhibit P12? P12 list dated 28/5/2006 with a heading. Read P12. P12. P12.
Article 6.
Now where is exhibit P12? Where is exhibit P12? List. Page 89. రాసుకోండి సంకల్పం.
Lordship, this was alleged to be given at the time of marriage, Lordship, but after the death of the husband, he is the only son of the appellant.
One second. There are two appellants, right? Both in-laws.
At the time of filing the OP,
M. Yadagiri and Yadamma. Yadagiri signature is there. First appellant signature is there on 89.
Lordship, at the time of filing the OP, the death of the mother-in-law was not the Lordship. Due to the death condition, she is not contested the OP, Lordship. At the time of filing the OP by the daughter-in-law, they were registered 65 Lordships. Now the appellants are registered 76 and 70 Lordships. They are not even government employees, not even government pensioners. The appellant hearing, appellant number 1 work as construction labor in Lordship. Appellant number 1 used to work as in hospital. Now they are registered 70 and 75 Lordships. They are given.
One second. There shall be interim stay of return of 2,95,000 together with interest. However, appellant shall continue to pay 1,000 rupees.
Yes,
You have been paying? What are your instructions? No, one second. You have been complying with this order 24/8/2011. Not now, from 2011 onwards. This interim order is 24/8/2011. What are your instructions with regard to at least complaints of 1,000 rupees maintenance? Get instructions. Any other ground? Only two grounds.
76.
That we will consider, age we will consider.
Construction labor. In such a circumstance, how to pay the maintenance to
Don't ask us, ask your clients. They will tell you. Next ground.
He's also having links to mixed also. But the appellants is not ineligible slot. Now they're depending on they're at the stage of depending on the slot. The six was the only son of the appellants and he said living behind the oldest parents.
Next.
Considering all these services.
Get instructions from your client with regard to payment of 1,000 rupees to the respondent. Right? And details of payment you have to produce. What's your name? So and so representing Mr. H. Srinivas Sudhakar Rao, Land Council for Appellant. In part for continuation, list on 15th in the caption for others. There is no representation on behalf of respondent. Yes, next week we will decide.
My lord, I beg to represent G. Anandam, my lord. My lord, request 2 weeks time, my lord. We have tried contacting the client, my lord.
Not necessary appeal. You can read the file and you can argue.
Was only
Statutory appeal, Mr.
Lordship, then 1 week time, my lord. That's the reason no instruction from the client, my lord.
What instructions you want?
Whether
You have
the-
received papers, you have filed appeal.
I've
Then
filed the-
what instructions? If you want material instructions to be received, we'll adjourn. Otherwise, no. Statutory appeal, you can't ask adjournment just like that.
Only for a week, my lord. I'm
Who
handicapped.
filed appeal? Record వచ్చింది. Husband filed appeal, seeking dissolution of marriage. Decreed, no? He and them all, wife filed it. Maybe he's agreed with is 6 lakhs rupees and 4 lakhs. The notice doing, notice. Notice to Kiran Mai. Biochemist, Certified Diagnostic Center, Himayat Nagar, Mumbai.
She's residing in the United States, my lord. She's residing in United States, my lord. United States, my lord, with the daughter. I'm unable to assist the court. I do not have the file with me, my lord. Your lordship, my grand.
File also.
My lord,
Very good.
I haven't bought the file, my lord.
Personal notice. Petitioner's counsel is permitted to take out personal notice. Where is the proof? That? ఇందులో ఏముందండి? Endorsement. Petitioner hence written. Party not claimed ఉంది. Party not claimed ఉందేనా? In complaints. Granted 6 lakhs rupees towards permanent help. We are agreed with that. Only 6 lakhs we have to decide.
I apologize, my lord.
It's matter. The council for respondent has given away the bundle.
I am appearing, Your Lordship, for the respondent. Yesterday I filed my, next week, Your Lordship may have.
2011 appeal, Mr.
And yesterday only I filed, Your Lord. Next
Yesterday-
Wednesday I'll be ready.
15th?
15th, yes, sir.
What's your name?
Jain Jasurya. Jain Jasurya.
Jain Jesuri. So and so accepts notice on behalf of 6:10
Name of Muthu Vijay may be deleted.
6:10 get instructions and list on record వచ్చింది
988.
list on 15th. Priest is directed to print the name of so and so in the place of
57.
Yes.
58.
15th.
Place. 287. Place.
Is filed by the husband in granting involving the marriage and granting permanent alimony of finance.
Execution petition claiming an amount for the sums of 1 lakh, out of which 5,000 is permanent and money 5 lakhs. The circumstances, there shall be interim stay as paper subject to condition of appellant paying 3,50,000 within a period of 8 weeks. So there is an interim order,
Yes,
8/9/2011. This court granted interim stay on the condition of appellant paying 3,50,000 to the respondent
That
within
has
8
been
weeks.
paid, ma'am.
Complaint.
Yes, that
Has
has
been
been
complied, my lord. There are still arrears of maintenance in the date of filing of the appeal.
And they are all first cousins only, ma'am.
1 second. Who filed OP?
Five,
My
five.
wife filed the
Wife Geeta Samuel.
Yes.
Second petitioner, Stundi
Daughter and
Francois Sonia.
Children, minor children.
Both are minor children.
Yes, ma'am.
Then-
Now they are major settled
Then
in Australia.
minor. So 2 and 3 are children.
Children.
What is the relief sought by them?
To dissolve the marriage and to grant maintenance.
Children and why children are parties to divorce application, madam? Dissolve the marriage of the first petitioner and respondent and granting decree of divorce to grant 50 lakhs towards maintenance, permanent element.
Yes.
What happened to the topi?
My lord, that has been partly allowed. Yes, my lord.
Respondent is directed to
And 5 lakhs as
the
permanent.
respondent is directed to deposit a sum of rupees 10,000 to the second petitioner, 10,000 to the third petitioner on or before. Monthly maintenance was awarded.
Yes, ma'am.
Then it is further directed 5 lakhs is awarded to the first petitioner towards permanent alimony. Ordered and decreed the second petitioner is entitled to maintenance amount till her marriage is performed by respondent so and so. So who filed this appeal? Husband filed.
Husband filed.
Hmm.
My lord, saying that granting, because she also received some amount by selling the property and all that was considered and 5 lakhs was fixed, my lord. Even agreed by that, we filed this appeal, saying that for both the children now they are settled in Australia. Daughter is not, he helps the daughter for going to Australia and spent the amounts and all that. Nearly more than 10 lakhs.
Both are staying in Australia.
Both the children are staying in Australia.
What about their marriages?
Yeah, they are all married, ma'am.
Both of them.
Yes,
Daughter was 17 years in 2007.
yes,
Son was 15 years in 2007.
yes, ma'am. Now they are in 32, 33 years.
Where is your client first petitioner wife? She is in Australia or in Hyderabad?
No, she is in Hyderabad only, my lord. I am trying to get in touch to get the present details. There was a proposal, my friend has a proposal.
She was 37 years at that time,
Yes,
plus 16 years.
almost
37, 37,
almost 23 years.
23 years.
23 years they have been staying away now.
My lord,
Since last 20 years.
he is in mid 60s, she is in late 50s.
That is what
So,
my
in fact, they are first cousins only. She's been visiting regularly to the house and he requested her to come and stay with him at this age because
not-
he has also had
She is
some
not
age.
interested?
She said, no, I'm not interested. I want money.
Only money.
I just checked, my lord, with my client. And because there is a cross appeal also was filed for the permanent alimony against the grant of 5 lakhs. He had also filed a cross
What
appeal.
about this 10,000 rupees?
My lord, subsequently we did not, because of the stay granted, my lord, we did not deposit. But we helped the children
daughter to go and settle.
Going to Australia and
At
also
the time of marriage and at the time of going to Australia, he has spent
if there is possibility of compromise, we will list it on 15th. Talk to your clients.
Yes, my lord.
Otherwise, we will decide on merits.
Yes, yes.
That would be better.
Yes.
Because already 23 years they have been staying away from each other. Now the question of one is permanent alimony because I had filed a cross appeal. Not satisfied with the grant of permanent alimony of 5 lakhs. Because he was working in Saudi Arabia for 23 years.
So you have filed cross appeal?
Yes, my lord.
Where is that?
That appeal is not listed, my lord. I have to check.
Appeal number?
My lord, the file is misplaced. That's why I was not able to give the appeal number to this.
At least do you have copy?
They did not serve any papers on, sir. No.
2000
Yes, OP 77.
Anyway, I will verify that.
Open cross appeal ఉంది. Appeal ఏమి లేదు, separate appeal చేసి ఉంటారు. Cross objections చేసి ఉంటారు. Anyway, heard Srimati D. Pramada, Land Council for Appellant, and Sri Bhupendra Mahendra, Land Council for Respondents, in part for continuation, list on 15th, in the caption for orders. 15th for orders.
Yeah, instead of 15th, 22nd.
15th, next Friday, next Wednesday.
My learned friend wants it on 22nd.
Next week, my lord, there is some personal difficulty.
2011 appeals,
I do understand, my lord, because of some personal difficulty, my
22nd in the caption for orders. In the meanwhile, registration call for the record from the board below.
Deeply.
Give the other FCA number.
Yeah, and just trying to praise because I lost the bundle. I lost the bundle of cross appeal, my lord. That's why I'm not able to give the number.
I just
Yes, Mr. Pune.
And for the wife respondent, your lordship, the husband appellant counsel had earlier expired, so notice was sent to the appellant.
Huh? Mr. Rakesh is appealing for appellant. OP is of 2010, appeal is of 2011.
The applicant has guided in the petition.
So,
We file a glad petition to bring the children on record.
appellant is no more.
No,
Nagendra Maulik
yeah,
is no more.
I think
Item 24.
24.
You are appearing in Raj. Huh?
Charles Amrit.
I think it's representing some
In
other.
which matter you are appearing, Mr. 24 FCA number 211 of 2011. Appellant name is Jammala Nadaka Nagendra Maulik. You are not there. Land Council for Appellant. Respondent is present. It is brought to so and so. Passed away. List is directed to issue notice to the. ఏమైందండి ఇప్పుడు అడ్రస్ లెఫ్ట్ ఒకసారి కవర్ చేయండి. ఇట్ అపియర్స్ అడ్రస్ లెఫ్ట్. Wife filed OP, right?
Yes, wife filed OP for divorce. It was granted, but that was against which the husband filed.
ఇది ఎప్పుడండి 11/4/2022. ఇది ఎప్పుడు మరి డోర్ లాక్ రిజిస్టర్ జ్యుడిషియల్ ఎప్పుడు 22 11/5 డోర్ లాక్ అడ్రస్ లెఫ్ట్ వితౌట్ ఇంటిమేషన్. We will order fresh notice, door lock. Address left without information, 7 days. And in complaints with order dated 11/4/2022.
Please, madam.
The record వచ్చిందో చూసుకోండి పెట్టుకోండి.
May please, madam. Husband appeal, my lord. Husband filed an appeal.
Who filed OP?
OP filed by the husband, my lord,
Seeking?
seeking divorce under section 13(1)(a) and 1(b). Cruelty and desertion. That was dismissed, my lord.
Dismissed.
And a switch present appeal is filed, my lord. Admittedly, my lord, the parties here are, yes, my lord. Admittedly, the parties are separated from since very long, my lord. More before filing of the appeal itself, this
Who is
HMO itself.
Who is PW2?
Maternal uncle, my lord.
One second.
PW3 is neighbor.
One second.
PW4 is the postman.
PW2 is maternal uncle, right?
Yes, my lord.
PW3?
3 is the neighbor.
So
4 is the postman, my lord.
why they have examined?
Postman was examined because legal notice was issued. She refused to take the legal notice. That's why the issue was examined.
Respond, wife examined herself as RW1. Who is Ishwaraya?
Ishwara is the father of the father. Is the uncle. Lakshman is the uncle, paternal uncle.
Maternal uncle. Maternal or paternal?
Paternal.
So what is this MC 125 application?
It's a maintenance case.
What is this OP 28 of 2002?
Restriction of conjugal rights.
She filed.
No, my lord.
No, he-
Husband filed, my lord.
Husband, one second, I take your stick. Sorry. Who filed OP 28 of 2002?
Husband filed, my lord.
Husband filed seeking restitution.
Yes, my lord. That
What
was
is
dismissed.
this OP?
Dismissed, my lord.
Dismissed. Any appeal?
No, my lord. No. No.
Restitution dismissed. This was also B2. Yeah, sorry. Did you go? Do you have copy of B2 with you? Dismissed, huh?
My lord.
OP was dismissed.
Dismissed, my
Oh, B2. Exhibit.
lord. Pass on, my lord.
We have original record with us. Any appeal filed by husband?
No, my lord. No.
So restitution dismissed and resolution application. Both
Yes,
dismissed.
yes, my lord. Only my humble submission before this court. I am not going to much. I'm not going to much of the speedings and all those things. My humble submission before this honorable court, the marriage is irrevocably broken down because since this filing of OP 2007 onward, they are not living. They are living separately. There is no chance of reunion, my lord. That is only my humble submission.
What about children?
Children, 2 kids, my lord. One daughter marriage is over, my lord. I am told that another daughter will go. My friend has to say.
Your friend will say so many things. You have to complete first.
Yes. One daughter already married, my lord. For that marriage, my instructions are there, my lord. His name was there. His uncle has performed. He has not informed for that marriage also.
So she is not interested.
She is not interested.
CHB. Sorry. అంతేనా ఒకటే ఆర్గ్యుమెంట్.
May I take to that judgment, my lord, for a moment?
See, cruelty and desertion, Mr. Manohar.
Cruelty it is not there. Only desertion on the ground of desertion, my lord. Cruelty could not prove because one thing, my lord.
According to you, what is the date of desertion or at least month, year?
Desertion, my lord. 2007, my lord.
Month? She left the company in 2001 by quarreling with him.
2000. No.
It is an admitted PW1 filed OP to 28 of 2002 on the file of sciences seeking restitution of conjugal rights.
Yes, my lord.
It's also an admitted fact that RW1 filed MC7 of 2003.
Sangaretti in February 2007. And the said case, the deposition that she is not ready to live with the petitioner. The petitioner waited for the respondent since February 2007. She is not willing to stay at Narsapur, my lord. Therefore, they have shifted residence at Sangaretti. There also they could not live because her parents, Hyderabad gaadu, parents are there. They used to come frequently and trouble him. పోయి అది కూడా తీసుకున్నాడు, రెంట్ కూడా తీసుకున్నాడు. ఇక తీసుకొని ఉండలేక దట్ ఇస్ మై ఇన్స్ట్రక్షన్స్.
He was addicted to alcohol and
It was not proved, my lord. It was not proved. It was not proved. Those allegations were not proved by examining any driver.
Desertion also you have to.
My lord, desertion we have proved, my lord. It is admitted fact, my lord. Your lordship knows admitted fact need not be proved.
Where is the finding with regard to desertion in the impugned order?
My lord,
Where is the finding? On what ground it was dismissed?
my lord, it was dismissed, my lord. Your lordship may kindly see.
2020.
Please come to page 19, my lord. Except saying that in the middle, my lord.
Page 22. Page 22.
Page 21 also, your lordship may kindly see, it is submitted that PW then went away to Narsapur to Sangareddy, RW1, and Sangareddy, and the ground that he is unable to bear with the torture of the RW1, father of the brothers. He stated that the mother used to visit the house and insulted him by having, in the middle, my lord, page 21, my lord.
The RW2 and RW3 shows they tried to patch up the differences by conducting panchayats at Narsapur, Sangareddy. But their efforts failed due to conduct of PW1. అది ఇంకొకటి కూడా ఉంది.
Page 22, your lordship may kindly see, my lord.
Conduct of PW1 is now in not taking care for his family members is also established by filing MC by RW1. Hence, evidence of PW1, RW1 left to him voluntarily cannot be accepted. Though PW1 stated that RW, page 22.
Yes, my lord. Page 22, except middle, my lord, your lordship may kindly see.
1, 2, 3, 4.
According to RW1, may I read, my lord?
Though you have to read from this. Though PW1 stated that RW1 in maintenance case deposed that she is not willing to live with him,
Yes,
he has not filed any documentary proof or deposition.
Question copies to show that RW1 stated like this, so and so, on the fact and circumstance of the case, it is quite probable that PW1, it is PW1 who harassed the RW1 and left her children and their own fate at Sangareddy. Hence, I hold that the petitioner failed to prove RW1 deserted him and subjected him to cruelty. That is the only ground. my lord.
Desertion కూడా prove చేయలే.
Desertion is admitted fact, my lord. Who is in question, my lord? Admittedly, they are residing 2007, my lord. 2007. No, because since she is not residing with him, she went away and she is residing with her parents. And admittedly, there is no chance of reunion, my lord. That is the only my humble submission. If there is a chance, I can understand, my lord, they can not be granted. But even in future also, now also, there is no chance for living together.
What about this maintenance case?
Maintenance, he is paying, my lord. He is paying maintenance.
Amount awarded.
I'm not aware, my 8,000 or 10,000 he is paying, my lord. I'm not aware.
You are for the husband, you have to answer.
8,000, 8,000,
No, given.
8,000.
Exhibit A, ఇందులోండి.
He is paying, my lord. I asked him, first question I was asked him, are you paying maintenance or not? That's the only question I posed him.
First question or second?
Again,
Second question.
chance in that again. Is there any chance to reunion?
2,000 rupees per month towards maintenance to the first petitioner, 750 rupees to the to petitioner student. 750.
Time to time it has been asked.
ఎప్పుడు announced?
That I am not aware. I'll get instructions, my lord, for that.
Respondent shall pay the arrears కూడా అన్నాడు అంతే. Enhancement లేదు.
Then I'll get that instructions. Regarding announcement, I'll get the
instruction whether they are paying the amount of maintenance, my lord.
So cruelty anyway, he did not prove. Desertion?
Desertion, my lords.
What are your instructions?
Lords,
Present instructions.
clients are not contacted, not that's why.
What to do? We can't wait for the parties.
Lords,
We will decide appeal on merits. Anyway, record is with us.
my lords,
If you want to get instructions with regard to payment of maintenance,
my lord,
but they are not in contact with you, how you are going to contact them?
lords, I will address the letter, my lords.
అయ్యే పని కాదు. పాత ఫైల్స్ అని దులపాలని చెప్పినాం కదా ఇప్పుడు.
My lords,
స్ట్రెంత్ ఇంక్రీజ్ కాగానే చెప్పేసినాం మీకు. పాత ఫైల్స్ అని దులపాలి. You have to address letters, get ready అని.
give me one chance, my lords, I will On Wednesday, I will.
Let's see. N. Manohar, Land Counsel for Appellant. What's your
In this matter, I have for the appellant husband. What happened in this matter, both married, love marriage, both are different community. After the marriage, after granting divorce, I filed appeal before this.
Who filed OP?
Husband filed.
Wife filed and
Wife filed OP and the lower court granted
seeking dissolution of
the marriage.
on the ground of cruelty.
Cruelty.
Ah.
Now, what my submit
That
was,
was-
both are, she also filed a 498 case, wife, and the case is ended acquittal. Thereafter, both are residing separately and whereabouts not known. It seems to be both settled. I will find out whether the case survives or not. What you kindly give it in 2 weeks time.
Case
I will report.
filed by wife was allowed.
Yes,
Your client filed appeal.
appeal. What my submit is, I will find out whether appeal survives or not. Both married thereafter, and report it so that Rafiq can dispose it of. Both are different communities. Wife belongs to Chaudhary and husband belongs to Reddy. Yes,
You are agreed by dissolution of marriage or permanent elimination? Please come to page 8. You do have bundle with you?
Yes,
in the ground number 24, Krandi, page 8.
That what Millard, I will submit Millard because client is not touch with me. I will find out and give in.
Request of Sri
2 weeks.
Sai Babu, Land Counsel for Appellants. List on 22nd in the caption. What the time will be granted.
Yes.
Yes. Either way, you have to proceed.
Yes,
But we elevated a judgment, notice may go to the party.
You are representing the
Counsel for the petitioner.
you don't have bundle. What to do? We'll give
No
out.
instructions.
If you want to prepare and argue.
The petition. Counsel or petitioner elevated a judgment. Notice may go to the parties.
OP filed by husband, Assistant Divisional Engineer, seeking dissolution of marriage on the ground of cruelty, desertion. That was dismissed. Therefore, appeal. Husband file appeal. Ain't endorsement. Same person. ఇద్దరు పేర్లు రామ్ గోపాల్ రావు అండ్ ఏఎస్ రావు అడ్రస్ వచ్చేసి జి కవిత వైఫ్ ఆఫ్ శ్యామ్ ప్రసాద్ G1 ప్లాట్ నెంబర్ 259 రోడ్ నెంబర్ 3 డాక్టర్స్ కాలనీ ఎల్బీ నగర్ హైదరాబాద్ సేమ్ అడ్రస్ ఎండార్స్మెంట్ ఏంటి కనిపిస్తుంది అంతే ఆఫీసర్ రూటెంటేషన్ అన్నారండి notice sent to respondent through RP area was returned unserved with an endorsement. No such person in this address. Hence, return to sender. List of as per section 27 of General Class Act. Sending notice to the respondent to the address available is sufficient. List of there is no representation on behalf of respondent. What's your name?
Krishnareddy. Krishnareddy.
Initial Japan.
D. Krishnareddy.
Sri D. Krishnareddy accepts notice on behalf of appellant and seeks time to get instructions. Where is
Madam,
it?
I'm appearing for the
This is
appellant.
your matter.
Appearing
You are
for the
presenting
appellant,
Sanmant.
Rakesh sir.
I belong to the same.
IA number 1 of 2019 is
Our
filed.
application, right? Where is Mr. Hanuman Reddy? Mr. Hanuman Reddy, LR application is there.
My lord,
Yes, Mr. Hanuman Reddy.
yes, my lord, I am there, my lord.
LR application is there, IA 1 of 2019.
Maybe allowed, maybe by allowed.
So who is second petitioner? Seelam.
They are the children of the first appellant. Children of the first appellant.
Both are sons.
Yes, because property dispute is involved. LR's
This application we are ordering, Mr. I will consider. Where is the death certificate?
Fortunately, I don't have the petition in my file. It
Very
is
good.
misplaced.
Page 4 of death certificate of Seelam Charles. Seelam Charles. Page 5. Shakuntala. Who is Shakuntala?
Wife.
Mr. Hanuman Reddy, it appears. Even you are appearing for which respondent?
I am appearing for the respondents, all the respondents, my lord.
And according to them, first respondent, your client is also.
First respondent has expired, my lord, that she is represented by her daughters 1 and 2.
I have 1 of 2019. Have been satisfied with the reasons mentioned therein and also considering the death certificates dated 22/11/2018 and 3/12/2018. This application is ordered. Mr. Beast is directed to carry out necessary amendments. What about appeal? You have to argue next week, both of you. Appeal you have to argue, Mr. Hanuman.
Yes, we did your lordship.
Appellant.
15th
or 22nd? 15th or 22nd?
22nd, madam.
22nd, yes, Sangeet.
Yes.
Obliged.
Senior end of survey insufficient progress. Venkata Sudhamani, wife. And here one. Yes. Against her divorce statement, 20 lakhs per minute. The result petition is allowed. Respondent is directed to 2 lakhs 50,000. ఇప్పుడు మీరు ఏం చేస్తే నిన్న మన రోజుకి ఒక పెట్టా నేను వచ్చింది ఇంటర్వ్యూ పెడతాను మరి ఇదేమంటే మీరు నన్ను అప్పేస్తారు అప్లై ఆ కవర్ ఏంటి MC 55 Hyderabad. Admitted notice. The notice sent by this court to the respondent is written and served. Correct. Government service 55. ఇది కరెక్ట్ అయింది నన్ను అప్పేసుకోండి ఈ IA number 351 of 2010 in the decretal order in dated 21st October 2010 in IA number 351 of 2010 in OP number C52 of 2026 sponsored by Family Court Hyderabad. The address of respondent is mentioned as follows. Put us on page 9 of the A to Z. Appellant mentioned the address of respondent as follows. Page 1 of B2. Redirect question. None appears for appellant. Please do. The cover written and served is without any endorsement. Like Adishi. It labeled nothing the substitution.
Right. Here for the petitioners of Mohammed Adnan Lodge.
Unclaimed it. We filed with friend. Grant of decree registration rates beyond dismissed. If you filed, okay.
Well, ascertain whether we have given NOC in this matter, Your Lordship. It's a 2012 matter. We do not have the bundle. We need to.
We are not concerned with all those things. As long as you are holding wakalat, you have to assist the court. That's all. 2011 appeal. We will give you one chance. That's all. Visitation rights application filed by husband was dismissed.
Yes.
2011. We are in 2023. Notice issued to respondent. Returned answered with an endorsement from. Yes.
It's matter when I'm appearing for the respondents in the.
Can you have next week?
2011, you can't
She's held up in the Rangaradi court, Your Lordship. She's held up in the Rangaradi court, so that's why. Can you have?
చెప్పొచ్చు
Afterwards, Your Lordship, I'm the
కనీసం సుప్రీం కోర్ట్ అన్నా చెప్పండి ఇది డివిజన్ బెంచ్
Absolutely, Your Lordship.
ఏం పాస్ ఆఫ్టర్నూన్ వీఆర్ నాట్ సిట్టింగ్ ఏం చెప్పాలని కూడా తెలుసుకోకపోతే ఎలాగ
At least it may be taken up tomorrow.
IA 1 of 2023 she filed application to receive additional material papers. What do you say on this? You want to file any counter or you are opposing or?
Just I'll go through tomorrow. Tomorrow it may be
It
taken.
was adjourned on 20th April. What is today?
Because we will argue the main appeal itself, my lord,
We are
because
asking you what do you say on IA 1? If we say yes, we will allow. Otherwise, we will decide on merits. At request of your own counsel for appellant list on 15th.
much obliged.
However, comfort that time will be. Contempt suspension is straight. When filed, OP, seeking resolution of marriage. Resolving which. But was allowed. Why the product? Class 27, section 27. It is mentioned like this what market. Since of one. None of this for. This. Yes. Yes, madam, ready? Prepares? 302.
PW1 is the eyewitness in your lordship. She is the wife of the deceased.
PW1 is the eyewitness.
The offense took place, the scene of offense is near the house of the deceased. The motive is that your lordship, that accused wife is having illicit intimacy with this deceased.
PW1.
With the deceased.
Who is deceased?
Deceased is the husband of PW1.
Husband of, accused wife.
So due to that, he decided to kill him, and
Who is PW2 then?
PW2 is a daughter of the deceased.
She is only.
She is a circumstantial.
PW.
She saw the accused running from the scene of offense after killing the deceased.
PW3?
PW3 is a neighbor. See, she is also circumstantial witness. She is sitting a little bit far away from the scene of offense.
PW4?
PW4 is also a circumstantial witness.
Okay.
PW5 is circumstantial witness. 5 of exhibit P1, he turned hostile.
6.
6 is for confession and seizure. Points to confession and seizure. PW7 is a doctor who contacted personal PMB.
What is the cause of death?
Cause of death due to the head injury.
Head injury.
Page number 40.
Where is FSL report? P14. He is in jail or on bail?
I am not having that information with me.
28 to 2018. Vatsalangarao criteria. No, none of this for appellant. We have heard land state public was list on 22nd. 39th next week. 15th month.
Like that. I'm sorry, my lord, previous occasion, I could not.
He's in jail or on bail?
He's in jail.
Then we will hear it. Right.
But since 7/1/2014, he is in jail.
Date of judgment?
7/1/2014.
7/1/20. Offense 3.
A1 to A3 at the appeals before the losses. But in history number 297 of 2008, on the file of 7th Judge Nizamabad at Bodal. At the time of filing,
Bail application for dismissed. Who filed appeal? A1?
no, all A1 to A3 filed appeals. But pending appeal, A3 was government issued a remission to A3.
Permission to A3.
A3.
A2?
A2 is a juvenile. I have filed a petition, and after receipt of the report from the district court, he was declared, he was set at liberty.
So now this appeal is in respect of only
A1. My lord, in the on 10th August 2020.
10th August 2022.
Yes, I have.
Seen from the inquiry.
No, last.
At liberty.
Yes. No, this the Supreme
decision with regard to the age of the.
At the time of hearing.
Accusations leveled against him would be decided when the appeal is finally heard.
At the time. Yes.
So now therefore you have to argue.
A1 to A1 and A2.
A1 and A2.
A1 and
Where is the remission order in respect of 3? You have copy? You have copy? Filed and
It's already.
చూడండి in the remission orders. What is the date of order?
2/10/2020.
2/10/2020.
2020.
Yes, Mr. Flow. So please concentrate on only A1 and A2.
Yes.
Is there any specific overt act against this A2?
No, my lord, this is a case of fisting and throttling. Throttling and fisting. This is the case.
I'm asking you, is there any specific overt act
No.
against the juvenile? Even his name is there in the complaint P1.
Yes. Lord, A3 is
Let's see P1 complaint first. Page 29. His name is Chinna Ashok.
Yes.
Chinna Ashok. Read exhibit P1. Page
నా మనవి ఏమన్నా నేను శ్రీమతి ఎంఏ పాపవ్వ వైఫ్ ఆఫ్ అమ్మబోయ 50 సంవత్సరం కులము పోయే వృత్తి కూలి ప్రెసిడెంట్ పిచ్చుకుందా గత 1 సంవత్సరం నుండి మాకు మరియు మా పాలెవాళ్ళు అయిన చిన్న అమ్మబోయలకు ఇంటి జాగా విషయంలో గొడవలు జరుగుతున్నాయి. మా ఇల్లు వాళ్ళ ఇల్లు పక్కన ఉండడంతో మేము రోజు వాళ్ళ ఇంటి ముందు నుండి వెళ్ళవలసి ఉన్నది. కానీ వాళ్ళు మమ్మల్ని వాళ్ళ ఇంటి ముందు నుండి వెళ్ళవద్దని ఎప్పుడు కొట్లాట పెట్టుకునేవారు. అదే విధంగా ఈ రోజు 22/3 నాడు ఉదయం కూడా చిన్న అమ్మబోయి మరియు అతని ఇద్దరు కొడుకులు చిన్న అమ్మబోయి A3 అతని ఇద్దరు కొడుకులైన పెద్ద గంగారం అశోక్ మాతో ఇంటి ముందు నుండి నడవవద్దని గొడవ పెట్టుకున్నారు. అది తెలిసిన నా పెద్ద కొడుకు అయిన ఎంకి చిన్న గంగారం డిసీజ్డ్.
A1.
డిసీజ్డ్. చిన్న గంగారం ఇస్ డిసీజ్డ్.
పెద్ద గంగారం A1.
All are agnates. Agnates. Accused and deceased are agnates. పెద్ద మూవీ 30.
Ashok ఉంటుంది.
Yes, Ashok. Ashok is there. In the complaint, all the 3 are there.
Irrigation చూడండి ఒకసారి.
రాత్రి 8:15 సమయంలో మేమందరము మా ఇంట్లో అన్నం తింటూ ఉండగా చిన్న అన్నబోయే A3 అతని ఇద్దరు కొడుకులు అయిన పెద్ద గంగారం మరియు అశోకులు మా ఇంటి మీదకు వచ్చి మాతో గొడవ పెట్టుకున్నారు. ఇంతలో నా పెద్ద కొడుకు చిన్న గంగారం బయటకు వెళ్ళి వాళ్ళను సముదాయించాలని చూస్తుండగా చిన్న అన్నబోయి పెద్ద కొడుకు అయిన పెద్ద గంగారం ఏమని నా పెద్ద కొడుకు చిన్న గంగారామును చంపాలనే ఉద్దేశంతో గొంతు పట్టుకొని గట్టిగా పిసుకుతుండగా
ఎవరు గొంతు పట్టుకొని
ఏమని చిన్న అన్నబోయి మరియు అతని చిన్న కొడుకు అశోక్ కూడా చేతులతో ఇష్టం వచ్చినట్లు కడుపులో కుదినారు. That is the vote act attributed
A2.
A2 and A3.
A3 and A3. నేను నా భర్త
A1 protected the neck.
What about who is eyewitness?
P1, PWs 1 to 5 are claiming to be as an eyewitnesses. PW1 is the mother of deceased. PW2 is the brother of deceased. PW3 is the brother-in-law of deceased. PW4 is sister of the deceased. PW5 is the brother of deceased. Lord PW6 is the punch for scene of offense. He did not, and inquest. He did not support.
PW6
Is the punch for scene of offense and inquest. He did not support the case of prosecution, turned hostile. PW7 and 8 are confessional punch. They did not support the case of prosecution. They turned hostile. 7 and 8. PW9, punch for scene of offense and inquest. PW10 is the photographer. PW11 is the doctor who conducted autopsy. PW12 is the investigating officer.
What is P11? Exhibit P11.
P11 is the confession panchanama, but they did not, they turned hostile.
Gangabai and Narsabai, both of them turned hostile, right?
Yes.
What basis conviction was recorded? Where is the finding?
Lord, Lord's my clarity.
Relying on PWs 1 to 5.
Yes. Yes, eyewitnesses.
What is the first submission?
And my first submission, my lord, this is a case of throttling and twisting. There is no knowledge on the part of the accused to kill the deceased. It's only dispute, passage dispute among them. There is no knowledge on the part of. So 304 will attack, not 302. My lord, next submission, my lord. Contradictory versions given by eyewitnesses.
PW 123.
Yes. With regard,
What is the contradiction according?
PW is one.
Contradiction is with regard to presence of the accused or twist or throttling or.
No, my lord, PW one is saying that A1 to A3 entered into the house and A2 by cordon of the tough dragged him out and beat.
That is PW.
PW1.
PW2.
PW2 is says A2 took him deceased. A2 alone took him deceased. PW3 says
Please come to page 12. Page 12. Chief examination of PW1.
yes.
A1 to A3 came to my house.
Yes.
In night they took the deceased outside of the house. By caught hold his hairs. A1 to A3 gave fist blows
Yes.
in his mouth and kicked him by caught hold his neck and arm.
Yes.
As a result, he died. Let us see the doctor's evidence.
Doctor's evidence is
Please PW.
11. At page
Cause of death by
26, page 26.
asphyxia of death.
As you said, you do.
And smoking.
Yes. But he has noticed it's semi-digested. But the presence at the time of
Next.
contradictory versions among PWS 1 to 5. PW1 is saying categorically saying that all the three.
Where is the evidence with regard to throttling? No.
No.
Caught hold of neck అంటున్నారు అంటే even mother, sister.
The defense cases that that the incident was happened on holy day. The incident was happened on holy day. Holy day. The defense suggested that the deceased consumed poison and he had epilepsy disease.
Doctor's evidence.
Right.
Doctor's evidence చూడండి.
No, that is not. But suggestion of defense is he had epilepsy and his wife left.
Where is the cross examination?
Yes.
To that effect.
PW1.
PW?
1. The deceased was married at the time of his death. The wife of deceased went to her parents' house and she came back after the death of deceased. The wife of the deceased went to her parents' house 2 months prior to the incident. It is not, it's a suggestion, it is not to suggest that the wife of deceased went to her parents' house after quarreling with us and we went to her house to bring back her.
Evidence is contrary to this, right?
But it's only defense case. He had epilepsy and on the day he had blood, alcohol contents are found in the postmortem report. Alcoholic contents found in the postmortem report.
Exhibit P?
9 at 53. Blood page 57 evaluation content. Stomach and its contents. Saturated solution of sodium chloride rectified spirit, and sample of liver, saturated solution of sodium chloride and rectified spirit. Blood, rectified spirit. Urine, rectified spirit. It supports the theory of defense that he has consumed alcohol on that day and he fell on his own and died, taking advantage of the disputes. What?
It's not the medical evidence, is it? Next.
Well, with regard to A2 is concerned, the report of district judge is there. With regard to juvenile aspect is concerned, the report of district judge is there. Yes. So his age was 13 years and odd. So 13 years, 9 months, the district judge as on the date of offense. So he is a juvenile. Declared the A2 as a juvenile, and regarding A1 is concerned, well, no weapon is being used. So 302 will not attract. May alter from 302 to.
Since 9 years he is in jail, 9.5.
Yes.
Is your lordship, as they are known people, they are the relatives, and motive was there because with previous.
Passes.
That fate.
Passes. Regarding passes.
And the PW 2 to 5 are the eyewitnesses in this, your lordship. There is nothing to disbelieve PW 1 to 5 because they were present at the scene of offense. And regarding the medical evidence, throttling due to smoothing, your lordship, it is when stated by PW 1 to 2 that they caught hold of the neck. So while caught hold of the neck, might be they are unable to explain whether he caught hold the neck or.
Appeal. Article 21, we have to go by the record.
Yes, sir.
We can't presume something and we can't write judgment. Right?
Yes, sir. So, but even if we go through the evidence of PW 1 to 5, there is a medical evidence is not sufficient in the case of the person. Enmity was there, your lordship, motive was there. They entered the house during the night hours and they quarreled with the deceased, your lordship. That is there, but not supported by the.
But see, he remember the two and counsel polite when dust in public place. Item?
Appeal against acquittal preferred by the state.
Ready?
Where is that 20?
Lordship permits that prepared the bill.
302.
Five murders has taken place in this case. 5 murders has taken place in this case. And 6 persons was shown as the accused person in this case. Respondents was shown as accused in this case, your lordship. They have been acquitted by the lower court. All the persons have been acquitted.
You are appearing for all 6.
For all. Yes.
Take your check. We'll hear her first.
Yes. But my hearing requires a time in this case, your lordship, to give some complete hearing at once.
That's what you have to do.
Yes.
Your request should be very specific.
Yes, your lordship.
Just now you said
I'm ready with that one, but if time permit that it may not be urgent because it's a case where the lower court has come to a conclusion correctly and acquitted the accused person. So
we have to test whether pending of the lower court is right or wrong. That's what we have to do in appeal.
So I may be given an opportunity to
if you want 3 days. Don't worry. One matter we are hearing since last 37 days.
37 days. I am following the matter also.
Yes, ma'am. Let her complete first.
Yes, sir.
I'll read the brief notes here. Okay, let's start with the report.
Please. How many eyewitnesses are there? According to-
PW1, only eyewitness is only 1 year.
Who is it?
PW1.
PW1 is the only eyewitness.
One eyewitness. Remaining are the
How
circumstances.
many deaths according to?
5 deaths.
5 deaths. 9 accused, 5 deaths.
Yes, sir.
On what ground they were acquitted?
The Sessions Court disbelieved the evidence of PW1, saying that
Let us go to PW1 state.
page number 18.
18 days. Read chief and cross both.
I am the resident of Parsipuras in Rabat. I am a housewife. LW3, the being is the younger sister of my living husband by name, Muhammad Abdullah. Yeah.
She is the wife of the deceased.
Yes, wife of the deceased, T3.
Wife of D3.
LW2, so and so, this D1, Muhammad Kamiruddin is my father-in-law. D2, Sajida Begum is my mother-in-law. D3, Muhammad Abdullah Bini is my husband. This is number 4. Muhammad Kirmani is the younger brother of my husband. This is number 5. Neha Afif is the younger sister of my husband. I know accused 1 to 4 present in the court hall. I do not know the accused number 5 to 9 present in the court hall. Accused number 1 is the husband of the deceased number 5. Neha. T2 and A2 and A3 are the brothers of accused number 1. A4 is the brother-in-law of accused number 1. My marriage with my husband, Muhammad Abdullah Biabani, was performed on 2010. After the marriage, I was residing with my husband in the house situated at Premnagar, Amberpet, Hyderabad. In the said house, my parents-in-laws, disease number 1 and 2, and disease number 3 to 5 are residing. I learned that marriage between disease number 5 and accused number 1 was held during November 2008. I learned that Neha Afrin was residing in our husband's house even after marriage, since there were dispute between her and her husband since 2 months after her marriage. The dispute between them was that the deceased accused number 1 was demanding for additional dowry. The said Neha Afrin filed a grievance case against accused number 1, and she also filed a maintenance case against her. In that maintenance case, she was awarded maintenance of rupees 4,000 per month by the court. But accused number was not paying that amount for 10 months. On 30th 5/2010, at about 6:15 a.m., myself, my parents-in-law, my husband, my sister-in-law, my brother-in-law, this is number 1 to 5, were present in our house. At that time, my father-in-law even opened the main gate of our house and kept the vehicles outside the house, and he was again coming inside the house. The accused number 1 to 4 forcibly entered into our house. The accused number 1 firstly entered into our house. They have bolted the gate of the house. Then the accused number 1 first beat my father-in-law D1 with an iron rod on his head. My father-in-law started shouting, and then my mother-in-law T2 came into the veranda. The accused number 1 beat her also with the same iron rod on her head. Both my parents-in-law fell down with the bleeding injuries on their head. The deceased number 3 to 5 came to the veranda from inside the house, and all the accused number 1 to 4 began to beat deceased number 3 to 5 with iron rods and sticks. Deceased number 3 to 5 also fell down on floor. I was also present there. By the time my husband entered into the veranda, and he pushed me into the hall adjacent to it and bolted the grill gate of it. That's why she is saved it. Because her husband bolted her inside the grill gate. Then accused number 1 to 4 left the house. Then I informed about the incident to the husband of sister-in-law by name Muhammad Akhar by cell phone of my father-in-law. Sister-in-law, he is a PW2.
Who Akhar?
Akhar is the husband of PW2. The said Muhammad Akhar was residing near our house. Then I informed about the incident to my father by the cell phone. Then Muhammad Akhar came there within 5 or 10 minutes. Later, my father came within 5 or 10 minutes. After Muhammad Akhar came there, Muhammad Akhar telephoned to 108 ambulance. Thereafter, police also came there. After police coming there, I preferred report to police by sitting in the house opposite to our house. One PC drafted the report and I signed it on it. Exhibit one is my report to police dated 30th 5 2010. It contains my signature. Police examined DBs number 1 to 4 at the spot itself. Whereas my sister-in-law Neha Afri died 3 days after the incident while taking treatment at Uthmania Hospital. According to the inquest, Your Lordship, she was unconscious. That's why if a DD is not recorded, and there was a throat due for doing such surgery, there was a hole in her throat at the time of that's why DD is not. I cannot identify the rods and sticks that were used by the accused during commission of the offense on the cross-examination. Prior to my marriage with my husband, my family and the family of my husband were strangers to each other. Since January 2010, when there was an engagement for my marriage, I learned about the affair of the family of my husband. Prior to that, I was not having knowledge of those affairs. It is true that for the first time, I am speaking about my learning of my husband's family affairs in the month of January in this book. It is true that in Muslim custom, the Muslim bride shall not participate in marriage proposals, etc. It is true that prior to my marriage, I did not meet any of the members in the family of my husband. It is true that it is the custom of Muslim that after the marriage, the husband and wife shall visit the house of in-laws of husband on every Friday and stay there in the in-laws house till Monday for a period of 5 months. It is true that prior to my marriage, I was not having acquaintance with accused number 1 to 4 as they were not related to me or known to me then. It is true that accused number 1 to 4 did not attend or participate in my marriage. It is true. It is not true to suggest that accused number 1 to 4 never came to my in-laws house after marriage till date of alleged. Witness volunteers that accused number 1 to 3 have visited in my in-laws house for 2 to 3 times after the marriage. That's why TAB is not conducted. It is true that I did not state about the accused number 1 to 3 visiting the house of my in-laws for 2 or 3 times after the marriage in any of my statements before the police or before the magistrate. It is true that I, being Pradhanasheen lady, I never came out before the strangers, including the accused who are also strangers to me. It is true that I did not meet the accused number 1 to 3 when they came in to my in-laws house or for 2 or 3 times, but I saw them. It is not true to suggest that I never saw the accused number 1 to 3 at any time. And my contention that accused number 1 to 3 came to my in-laws house for 2 or 3 times, and I saw them at that time is all false. It is true that since there are a dispute between accused number 1 and deceased number 5, the accused number 1 to 3 and their family members were not invited to the house of my husband for any purpose. It is not true to suggest that I do not know personally about the dispute between accused number 1 and deceased number 5, and I am reporting falsely. It is true that in my report to police, that in my statements to the police and magistrate, I did not say that how I learned about the dispute between accused number 1 and deceased number 5. It is not true to suggest that prior to my preparing report to police, I was not aware of the names of the accused number 1 to 4. It is true that in my report to the police and my statement before the police and magistrate, I did not state that how I learned about the names of the accused number 1. After my marriage, I never visited the house of accused number 1 and 3 along with my husband. It is true that I am not having any acquaintance with gate numbers of the house of the accused number 1 to 3. The width of the gateway of my in-laws house is about 5 feet. The distance between the gate and the veranda of my in-laws house is about 10 to 12 feet. There were a Chetak scooter between the veranda and the said gate. There was another two-wheeler also there before the kitchen room of the said house. It is not true to suggest that the person standing in the veranda is not in a position to see the happenings in front of the kitchen room of my in-laws. House kitchen room is situated at the side of the veranda. It is true that after satisfying myself and regarding the contents of exhibit P1 and signed in it, witness volunteers my third language is Telugu. Therefore, I know Telugu little. After narrating the entire incident, exhibit P1 was prepared. I signed on it. At the time of my preparing report to police in exhibit P1,
my father LW2 Mohammed Athar and my sister-in-law LW3 Jabin were present beside me. It is true that I preferred exhibit C1 at about 10 a.m. on the date of the offense. It is true that before preparing the report to police, my father, LW2 Mohammed Athar, and LW3 Jabin came and they talked with me and there was discussion among us. It is true that exhibit P1 is not specifically stated that I witnessed the incident. It is true that I did not give the names of the accused number 3 and 4 in exhibit P1. I did not go to Usmania General Hospital on that day. It is true that my exhibit P1 and my statements before police and magistrates, did not state that I contacted Mohammed Athar with the cell phone of my father. It is not true to suggest that I did not state in my report or in my statement before police register that I witnessed the incident from Varanda. It is not true to suggest that I did not state in my report police or this my statement before the magistrate that I am residing with my husband along with the parents-in-laws and sister-in-law. It is not true to suggest that I did not state in my report to police and in my statement before police or that my in-laws and my husband were residing along with my in-laws in the same. It is not true to suggest that there is no gate as such in the house of my in-laws and if the purpose of this case and deposing mostly as well. It is not true to suggest that governments in my examination in chief attributed specific attacks against the accused number 1 to 2. In 1 to 4 are false. It is not true to suggest that I was not present at the time of alleged incident and on that day I was at my parents' house and later was called and planted as a witness for this case by the police. It is true that I retired again after the incident in this case. It is true that my present husband is related to me prior to my marriage with him. My second marriage was performed on 2/3/2011. It is not true to suggest that I was having affair with my present husband prior to marrying him, and then I was not interested in marrying my first husband. I was not called by the police for identifying any of the accused in this case. It is not true to suggest that prior to giving evidence in this case, police have shown the photographs of accused to me. It is true that I did not see the accused number 1 to 4 subsequent to 30th 5 2010 in the date of and this is in this case till date. Cross-examination by A3 to A9. It is true that I did not find any documents to show that there were cases between A1 and D5. At the time of my giving exhibit P1 or the time of my giving statement to police or to the magistrate, I know the results of the case that were registered against the accused number 1. It is true that I am not having documents pertaining to the case against A1. It is true that my report to police or my statement to the police or magistrate, I did not give details of the cell phone of my father-in-law, through which I called Mohammed Athar and my father. It is true that in my statements to police and in my report to police, I did not state that what times after the incident LW and my father reached the scene of offense. It is true that in my report to police and in my statement to police, I have not stated about Mohammed Akhtar calling for 108 ambulance and like police coming to the scene of offense, etc. It is true that exhibit P1 and in my statement to police, it was not stated that after constable drafting report, I signed on it. It is not true to suggest that I did not state in my report to police or statement to police that the first instance Mohammed Akhtar came to the scene of offense and later my father. I do not remember that what time on which date on which police officer that recorded my statement, but it was recorded on the same day. I was examined by police in front of the house of my the police recorded the statement in Telugu language. It is not true to suggest that number 1 never participated in any offense and they are not responsible for the deaths of disease number 1. In this case, I am deposing falsely at the instance of LW2 other and LW3. It is not to suggest that I did not witness the incident.
Who is PW2?
PW2 is a sister-in-law of PW1 and daughter of that house. Means, she is a daughter of D1 and D. She is a circumstantial witness, your lordship, because as soon as the offense, she called her husband. PW3 third hostile. Or except for 1.2, all witnesses turned hostile. The sessions court disbelieved PW2 because
Where is the finding?
finding.
Of the sessions court.
Finding starts from paragraph number 39, your lordship.
Please,
Read from paragraph 39
please.
on page number 361. The present case, PW1 is the only eyewitness that has supported the case of the prosecution. But this PW1
One second. Yes, read.
But this PW1 is very much interested for the prosecution case, being the wife of the deceased number 2, and daughter-in-law of deceased number 1 and 2, and sister-in-law of deceased number 4 and 5. In this contention, this is the contention of the defense counsel, your lordship. Para 40, in view of the above decisions, it is clear that the quality of evidence it is required, but not quantity of evidence. In this case, there is only PW1 that has supported the case of the prosecution. This PW1 is interested in the prosecution case, and further, our evidence is not inspiring confidence. For identifying the accused for the first time in the court after the incident is not inspiring the confidence. Further, her presence at the scene of offense is doubtful as she did not sustain any blood stains, even though her husband was brutally murdered in the commission of offense.
Para 45 also.
In view of the above decision, it is clear that when the witness has gone to the extent of implicating one accused falsely, it is not safe to rely on the testimony of the said witnesses. In this case, PW1 has not given the names of accused number 229 in her report to police under exhibit P1, but she has named the accused number 1 to 4 while giving evidence before this court by improving her version from her report. Under exhibit P1, there is absolutely no evidence on record to show that PW1 is having prior acquaintance with accused number 1 to 4. Therefore, in view of the above decision, it is not safe to rely on the evidence of PW1 in this case. Shall I read paragraph 50?
Please read paragraph number 46.
40. It is
46.
It is true that in this case there are 5 murders and all the deceased persons belong to the same family. It is true that deceased in this case were murdered usually by the assailants. It is the contention of the learned counsel for the accused that it may be true that the offense in this case are gruesome and brutal, and one has to show much sympathy towards the deceased and their dependents. But at the same time, there should not be any hostile atmosphere against the accused. The prosecution has to prove the guilty of the accused beyond reasonable doubt. When there are no other witnesses, only PW1 is the only eyewitness because it was the morning hours, your lordship. So that is 6:15 a.m. So there are no other eyewitnesses because it was early in the morning. only PW1, she was a resident of the same house. That's why she is an eyewitness. She is a natural witness.
48.
48. In view of the above observation, it is clear that the case have been decided by the court strictly on evidence, however cruel or horrifying the crime may be. There is no dispute regarding the said observation of the Honorable Supreme Court. 49. It is a condition of the additional public. 50. Further, in this case, there is absolutely no evidence on record to connect the accused number 5 to 9, who are the women accused. Even PW1 has to state anything against this PW5 9. If there should be accused number 5 to 9. Even the learned additional public prosecutor has fairly represented that there is no case at all against the accused number 5 to 9. 52. Further, in this case, PW1 has stated that by the time her husband entering into the veranda, he was has pushed her into the hall adjacent to it and bolted the grill gate of it. So, according to PW1, she was able to see the occurrence through the grill gate. But PW22, the investigation officer who prepared rough sketch of the scene of offense under Exhibit P7, has stated that it is true in Exhibit P7, the scene of offense rough sketch, the grill gate of the house of the deceased, number 1, is not shown. If at all there is a grill gate adjacent to veranda in which the offense has taken place, certainly the said grill gate would have been noted in the rough sketch under Exhibit P7 by PW20. Even in the report under Exhibit P1, PW1 has not stated that she has not stated that her husband pushed her into the hall adjacent to the veranda, and it has also grill gate, and through that grill gate she has witnessed the occurrence. So it is also circumstances creating doubt about the prosecution, because your lordship, Exhibit P1, that is FIR, not an encyclopedia alert. She stated everything in her statement. And about the grill gate, it is not mentioned in the, it's true, it is not mentioned in the rough sketch, but that grill gate is the inner portion of the house. That cannot be drafted in the rough sketch. It is true that they should have presented the photographs of the Para 54. Since in this case there is a delay of referring report to police and the names of accused number 2 to 9 are not noted in the first information report, there is no evidence to show that PW1 was having prior acquaintance, even at least obviously acquaintance with accused number 1 to 4 prior to the date of offense. Her identifying the accused number 1 to 4 for the first time in the court cannot be accepted. And in view of my discussion, I am constant to come to the conclusion that the evidence on record is not sufficient to come to conclusion that the accused have committed any offences, much less the offence leveled against them in this case. Therefore, I am constant to come to the conclusion that the prosecution have failed to prove the guilt of the accused number 1 to 9 beyond all reasonable doubt for the offence punishable under section 148, 120B, 452 of IPC against accused number 1 to 9. 302 IPC under 3 counts against accused number 1. 302 read with 149 of IPC under 3 counts accused number 2 to 9. 302 of IPC against number 2 to 3. 302 read with section 149 of IPC against 1 to 4 and 2 9. 302 against accused number 2 to 4. 302 read with 149 of IPC against accused number 2, 3 and 5 to 9. Hence, these points number 1 to 7 are hereby answered against the prosecution. She said that she is having prior acquaintance with, in her cross-examination, she clearly stated that she know them.
She know only A2, A1 to
A1 and 8.
Next.
So with the evidence of PW1 should be believed with regard to at least A1 and A2, your lordship, because A1 is a husband of D5, and even her marriage occurred after the marriage of that her daughter-in-law. Might be because she knows that, she says that she knows them, she saw them. She is not seeing them for the first time in the court only. She saw them previously also. Even by, when the defense counsel cross-examined her on this aspect, she clearly stated that about that she knows A1 and A2. And the motive is that your lordship, as there was a maintenance case and divorce case was going on, and then the one thing is that that is mentioned in the charge sheet that due to that the mother of the A1 died, and they did not went to attend the funeral also. On that aspect, there was a quarrel, and they had A1 to A9 attack them. But in this, your lordship, even if the name of the other accused are not mentioned in the complaint and FIR, but the name of the A1 to A4 is mentioned. And with regard, if we reduce it to A1 to A2, she knows that A1, she knows she is having prior acquaintance with A1 and A2. So with regard to that A1 and A2, the appeal should be allowed.
So basic concern in the case, your lordship, evidence of PW1, evidence of PW22, and scene of offence. Who is PW22? Investigating officer. And scene of offence Panchnama has to be taken into consideration.
P6.
Yes, your lordship. As far as accused number 2 is concerned, from 2 to 9, no names have been stated anywhere by any of the witnesses in this case. My learned friend has submitted saying that there was no eyewitnesses at the time, but as far as the prosecution story is concerned, PW3 to PW5 have been cited as eyewitnesses that they say that one they heard the hue and cry and they have identified the persons who has committed the offence as per the prosecution story in the case. But as far as the evidence before the court is concerned, they have not supported the version of the prosecution in this case. So my submission in this case is that they have around the case. First, I will take your lordship to exhibit P1 in this case, your lordship, page number 77. '79 is the English version in this case. I, Nishat Begum, wife of Abdullah Biabani, age 25 years, housewife, resident of Suransa, Premnagar, Amberpet. I submit that my marriage was performed on 18/2/2020. This date may be taken into consideration. The date of incident has to be taken into consideration. Because in the month of May, she is a newly married bride entering into the family. And as far as the case of the prosecution is concerned, the accused persons was having a dispute with the deceased family, and they have not been at visiting terms at any time. In the marriage also, they have not attended the marriage. And it's the case of the prosecution that when the accused mother dies, the deceased and the deceased family members has also not attended them in this case. So the relationship has to be taken into consideration that the marriage was performed in the month of March, and the incident has taken place in the month of May.
It was on 18/2/2018.
18 February, sorry, 18 February 2010. And the incident has taken place on May, in this case, your lordship. So when, at what time after the marriage, she had a chance that this accused person had visited the house, because they were not at visiting terms at any point of time, has to be explained by the prosecution in this case, your lordship. On 18 February 2010, with Abdullah Biabani, my sister-in-law, Niha bin marriage was performed 2 years prior to with Sayyid Jahangir, resident of Patel Nagar. As the behavior of Sayyid Jahangir was not well with my sister-in-law, Neha Jabin filed a criminal case in Nampally Criminal Court, and at present the case is running. Keeping that issue in mind today, that is on 30/5/2010, at about 6:15 a.m., when my father-in-law, Kamruddin, has opened the house gate in order to keep his vehicle inside my house. At that time, said Jahangir Sharif and their henchmen criminally trespassed into my house with deadly weapon, iron rod, and attacked on my father-in-law, Amruddin, mother-in-law, Sajid Begum, my husband Muhammad Biyabani, and my brother-in-law Muhammad Karim Kirmani. My sister-in-law Neha Jabin indiscriminately on the head and body, which resulted in the blood injuries. Later, the miscreants has run away. That resulted after the death of my husband, father-in-law, and my husband and my brother-in-law and my sister-in-law received serious head injuries, and she is also critical in the condition in the Osmania hospital in this case. Your Lordship, this incident has taken place at 6:15 in the morning, and a complaint has been lodged at 10 a.m. in this case, Your Lordship. Delay of 4 hours in lodging the complaint. She says that the police has come there, the ambulance services has come there, they have shifted. According to, there is abnormal delay or only delay? Abnormal delay of 10 hours. Yes, Your Lordship. 4 hours. There are 5 deaths in the family. 5 deaths in the family, police has reached the spot. It is not the case that police has not reached the spot. When the police is present at the scene of offense, if the police or they would have gone to the police station, going to the police station and lodging a complaint is a different thing. Where the police has come to the spot, that not only the police, because I am by referring to the evidence of PW, the assistant commissioner of police, inspector of police, were at the spot at 7 in the morning, they say that one in the when the senior police officers was at the scene of offense, a sumoto case could have been registered and later on they would have examined the person in this case, Your Lordship. What time they came to this scene of offense? By 7, before 7, they said that one. 6:15, the incident has taken place. The senior officers like this, 4 hours is not a delay, according to us. I'll submit to on that point also in this case, Your Lordship. Next. So now coming to the evidence of PW1 in this case, Your Lordship. Trial court can't say a witness has interested witness. Is it not? The trial court has not stated that the eyewitness are interested. The trial court said that the PW1 was not having any opportunity to see it. To that extent, okay, but see the, please come to page 361, paragraph number 39. Paragraph number 39. In the present case, PW1 is the only eyewitness, and that has supported the case of prosecution. But this PW1 is very much interested to the prosecution. Here being the wife of the deceased number 3 and the daughter-in-law of the deceased number 1 and 2 and sister-in-law of deceased number 4. The court says that she is an interested witness who is the only eyewitness available. Trial court can't. Is it not? Next. Because as per the statement or observations, the trial court are also practicing criminal side. Trial court has not acquitted the wife. She is the wife. Yes, sir. Of D5. Yes, sir. Can the trial court say an eyewitness has interested witness? Right, by submission. I'm asking you with your experience, your assistants. You are also practicing in trial court. That was not even your defense during trial. Yes, but the observation here, the trial court has not acquitted the accused person only on the single ground, saying that not on that. Saying that one PW1 is an interested witness as such. Trial court has acquitted the accused person. Trial court disbelieved PW1's version, deposition. Not on the ground saying that she's the interested one. Ultimately, I believe the deposition of PW1. Disbelieve the deposition of PW1 on various grounds, but saying that whether she was having any opportunity to see the accused person, whether from where she has seen, her version is being matched with the scene of offense. The crime is not there in the scene of offense. Yes, Your Lordship. 3. That one is taken. And delay in lodging the complaint. Mentioning the names of other accused persons which had not been stated in the complaint. A1 to A4 she has stated. A1, she has stated that one A1 to A4 in this case. But as far as other evidence also is concerned in this case, just come to finish PW1. It's not. Land Assistant Public Prosecutor and the Sri Muzaffarullah Khan, Land Counsel for
respondents accused in part for continuation 15th or 22nd.
Any convenient data. Convenient
22nd. 22nd.
Much.
Now you have clarity, right?
My lord, there are, my lord, two orders which were under, a common order which has been under challenge, my lord. My lord, if I may be permitted to, my lord, the discrepancies with regarding to the interim order, passed by this honorable court in FCA.
Who filed FCA? OP number 295.
295 filed by the, my lord, wife.
Seeking restitution of.
Yes, my lord. That was dismissed, against which we have preferred this FCOP. In this, my lord,
OP number 680 of 2020 was filed.
Filed by the husband seeking divorce.
That was allowed.
That was
And you have filed a separate appeal.
Yes, my
So there also we have granted interim.
Yes, my lord.
So now, 1 second. What is the IA number? IA 2 even. Yeah, appeal. What is the prayer you are seeking?
My lord,
Suspend the orders dated 29/12/2022 in OP number 295 of 2016. That is the prayer.
Yes, my lord.
Can you seek suspension of a dismissal order? Is the question. You can.
My lord, I sought, assuming so, but on that, what my lordships were under the impression that since the divorce order is the order, that's why.
First of all, filing this application itself is.
My lord, they have sought for.
Seeking dismissal of the suspension order.
My lord, for the reason because if that is not suspended, my lord, my grievance is the maintenance, interim maintenance which has been awarded has been put to stay.
What is the interim maintenance?
In the suit, my lord.
Which suit?
The OP number, my lord, my 295 2018.
So in 295 maintenance was awarded.
Yes.
Very good. That you have to show.
That is what, my lord, if the lordship sees the order.
Let us see the order.
Yes, my lord. Penalty may come if your lordship quickly see.
Page number.
My lord, page 37. My lord, para 42. Concluding part, I'll just read for the convenience sake.
OP number 295 is dismissed. OP number 680 deserves to be allowed granting due. It is well settled that there is no separate application. The court can grant maintenance alimony basing on the permanent, basing on the facts and circumstances. Therefore, I am considering PW1 is entitled for permanent alimony of 50 lakhs. In the result, OP 680 of 2020 is allowed by dissolving the marriage between so and so respondent. So this is the direction in OP 680. Therefore, you are not supposed to file this IA2. Not correct, Mr. If she executes this order by way of filing EP, then you can come to this court, file a suspension.
May I just be prepared for a minute, my lord. Application being filed, but your lordship, my lord, under the my lord, your lordship may kindly wait for a second.
We are committed.
No, after my lord, after noticing that mistake, I was asked to file the application, my lord.
First, you have to file proper application with proper after going through the order properly. And
my lord, of my application, if your lordship sees the interim order passed in my application for seeking restitution of conjugal rights, the recital is there of 18,000, page 27, my lord.
The order. Page number?
27, my lord.
Paragraph.
My lord, Roman 2. During the pendency of the proceedings in MC, the court granted interim maintenance of 10,000 per month. Thereafter, the respondent approaching the Honorable High Court, the Honorable High Court will order so and so, they will reduce the interim maintenance from 10,000 to 8,000 per month together. Your Lordship got it, my Lord. Thereafter, then the final order, then it is passed in the common order. If your Lordship says, my Lord, time was 0.2, my Lord. I'll just read page 38.2, my Lord.
Page 38.
Page 38.2, my Lord. The respondent is directed to pay 50 lakhs towards permanent alimony to the petitioner. The respondent is directed to deposit 50 lakhs in her account. The decree of dissolution of marriage will be effected after depositing this said amount. By stating so, default clause being not there, my lord, I am till now the maintenance which is granted earlier in at the time of dismissing my application in the my lord, restitution of conjugal right, which I just read to my lords, that is not paid till date, my lord. They stop continuing paying them an amount.
Seek execution.
That is the day, my lord, I sought for suspension because that order is dismissed. If your lordship sees,
You have clarified.
Very,
You can file execution.
very well. Deeply.
You have to file execution petition 60.
Yes, I understand. I only sought that clarification, my lord.
You have clarified.
Deeply.
If you want any further clarification, file another.
And deeply applied.
Item 208 and 209. All Mahadevan. What's the government said? This is said.
ఇది మన కానీ అది లేదు. అక్కడ ఏ పేజ్ ఉందో చూసి చూడాలి. ఎస్సీసీ మనకి లిస్ట్ ఇచ్చారు కదా మోరల్ నువ్వు కూడా అక్కడ కూర్చొని కోఆర్డినేట్ చేయాలి. ఇవన్నీ మిగతాను చెప్పేసి స్టాఫ్ కొట్టు కూర్చొని అప్పుడు స్టాఫ్ లో పెట్టేసి ఎస్ మినిట్స్ Yes, my lord, but the sentence, my lord, whether it comes under the rarest of the rare cases or not, quantum of sentence, offense, my lord, in proportion to, my lord, the punishment, my lord, the quantum of punishment, the proportionate aspect. Yes, ma'am. Paragraph 7042. ఇన్వెస్టిగేషన్ చేసింది సార్.
Paragraph 704, page number 6, my lord, 670. That is appeal, my lord. Yesterday it was with lordships, my lord. So that is, yes, 704. The punishment, my lord, the sentence, my lord, pronounced by the court in respect of each and every, the charge, my lord, the offense charged. So 704. So, my lord, ultimately, my lord, this is the death punishment, the death penalty is given to all A2 to A6 in respect of the offences, my lord, for which they were prosecuted, charge sheeted, and also charged, my lord. The charges also under 228 of CRPC I read for the lordship's consideration. My lord, here is lordship, my lord, may, because ultimately the sentence part is, these the 3 pages, the major punishment is the death penalty. For, my lord, the UAP offences as well as, my lord, the 302 and etc. My lord, may I read, my lord, first 3-4 paragraphs, because I have read all except the sentence yesterday. My lord, in the result, the accuser number 2 to 6 are found guilty for the offence punishable under section 120B of IPC, read with 302 IPC, criminal conspiracy. A2 to 6 are found guilty under section 121 of IPC, waging war against government of India, 121A IPC, conspiracy to wage war against government of India. Accused number 2 to 5 found guilty for the offence 122 of IPC, collection of men, arms for waging war. A6 is found guilty for the offence under section 122, read with 109 of IPC, my lord, for abatement. My lord, here, in addition, my lord, 2 to 6 is also there, the first 3, my lord, the 5 sentences of the paragraph 704. He was convicted for 120B, 302, 2 to 6. And again, my lord, specifically, and A6 is found guilty for 122, read with 109 of IPC, also, my lord, for abatement for collection of men and arms for waging war. And accused number 3 or 4 found guilty for the offence punishable under section 302 IPC. They also found guilty of offence punishable under section 302, read with 34, murder with common intention. Accused number 2 found guilty for the offence under 302, read with 34, 2 counts, murder with common intention. Accused number 5 and 6 are found guilty for the offence under section 302, read with 109 of IPC, 2 counts, murder with abatement. Accused number 3 and 4 found guilty of offence punishable under section 307, attempt to murder. A2 to 4 are found guilty offence under section 307,
read with 34 of IPC, 2 counts for A2. A5 and A6 are found guilty for the offence 307, read with 109 of IPC. Lord, the accused number 4, found guilty offence under section 316 of IPC, causing death of kid unborn child. Accused number 2 and 3 found guilty for the offence under section read with 360, read with 34 of IPC, common intention to cause the death of quick unborn child. And accused number 5 are found guilty of the offence under section 316, read with 109 of IPC, abasement to cause the death of a quick unborn child. And accused number 3, 4 found guilty of the offence under section 436 of Indian Penal Code, mischief by 4 explosive substance. A2 is found guilty for an offence punishable 436, read with 34, mischief so and so. 5 and 6 also 436, 109, abatement to mischief by fire, explosive substances. A2 to 4 found guilty of offence punishable under section 201 of IPC, causing so and so and so. Well, every the sentence part is concerned, particularly the result. It is necessary to go each and every sentence because no, ships are not saying anything. But reading like a the continuous reading, but definitely. So, but no, it's nothing will happen. But I'm clarifying. This is necessary. Yes, and A6 is found guilty of the offences under section 466 of IPC, forgery of record of court of a public register under section 474 of IPC, having possession of forged document, intending to use it as a zenine. Accused number 2 to 5 found guilty of offence under section 466, page number 672, my lord, the second paragraph. Abatement for forgery record of court, so and so, all my lord, for the same. A2 to 4 found guilty of offence punishable under section 3 of Explosive Substance Act, causing explosion likely to endanger life or property under section 5 Explosive Substance Act, possessing explosive under suspicious circumstances. A2 to 4 are found guilty offence under section 5 of Explosive Substance Act. A5 and A6 are found guilty of offence under section 5 of Explosive Substance Act, read with section 109 of IPC. A3, A4 are found guilty of offence under section 3 of Explosive Substance Act. A2 is found guilty of 3 of Explosives Act, common intention for possessing explosive under suspicious circumstances. 5 and 6 found guilty of offence punishable under section 3 and read with 109 of IPC abatement notes. Accused number 3 found guilty of offence under section 14 of Foreigners Act. 14 of the Foreigners Act 1946, page number 672, the last the paragraph. And accused number 2 are found guilty of offence under section 14 of Foreigners Act 1946, read with 109, for abatement of contravening the provisions of the Foreigners Act. Accused number 3 is found guilty for the offence under section 4 of Public Property Damages Act, mischief causing damage to public property by 5 explosive substance. 2 to 4 are found guilty for same section 4. But the ultimately 5 and 6 in the same paragraph, since they are not physically present here, under section 4 of Public Property Damages Act, read with 109 for abatement of for mischief damage to public property. And accused number 3 are found guilty of offence. Section 16 of Unlawful Activities Prevention Act, committing terrorist act. And A2 is found guilty of offence under section 16 of Unlawful Activities Prevention Act, read with 34 of IPC for committing terrorist act. A5, 8, 6 are found guilty for offence under section 16, read with 109 of IPC for abatement of the terrorist act. A2 to 6 are found guilty of offence punishable under 17 of Unlawful Activities, raising or collecting funds for terrorist act. 2 to 6, 18 or 2 to 6 found guilty of offence under section 18 of Unlawful Activities, conspiracy for terrorist act. Accused number 5 is found guilty of the offence punishable under section 19, harbor or conceal any person knowing that such person is a terrorist. And accused number 2, 4 and 6 are found guilty of offence under section 19 of Unlawful Activities Prevention Act 1967, read with 109 of IPC to harbor, conceal any person knowing that such person is a terrorist. Accordingly, A226 are convicted under section 235 2 CRPC for the above said offences. 226 are found guilty for section 10 of, not guilty, not guilty of section 10 of UAP Act, being a member so and so and so, 20 of UAP Act for being member of terrorist gang, under section 38(2) of UAP Act, offence relating to membership of a terrorist organization, 39(2) Unlawful Activities Prevention Act 1967 relating to support given to so and so. Accordingly, 2 and 6 are acquitted for Mulad section 10 and also Mulad section 20 of UAP Act. Well, my respectful submission for consideration. Yes, ma'am. Yes, 38(2) of UAP Act and 39(2) of UAP Act. This is what the sentence is concerned. For finding guilty, sentencing part, this is all the exhibits marked and etc. After pronouncing, after finding all the accused 2 to 6 are guilty, the 694 again court resumed on 19th December 2016.
Think of the judgment, think of the Supreme Court case pending there. That is the judgment of fraud. Sentence for 90.
Yes, ma'am. Well, it's 13th December 2016. That is no, that the judgment date 13th December, and this is the yes 19th December. So there is a some gap is there, and here Lordship may kindly see what the defense counsels have argued that no one has heard at the time of the deciding the quantum of sentence. That is not correct. Page number 694, my respectful submission. Land Special Public Prosecutor, paragraph 1. He is heard at the point of sentence. Defense counsel called absent. However, this court heard the accused individually on the point of sentence. Yes, my respectful submission for that aspect. What I am trying to say, when accused found guilty, if really the quantum of sentence, they know that when they were found guilty on 13th December 2016, the counsels were present. No, even otherwise they know the judgment. They know the judgment, and they know that the next date is also 16th December. They are bound to know. Even otherwise, these are all the court proceedings. And it's a legal obligation cast upon them to know it also. 16th December, if really if they wanted to submit anything, either they have to file a memo or something, or otherwise any petition for adjournment, nothing is on the part. Otherwise, at least the accused who were found guilty has to make a request orally to the court that my counsels wants to argue, at least to requesting the time. That is not there. Here, the trial court, particularly court, the court of criminal justice is a competent court. Malafides, we can't attribute for everything, because a special court is constituted. The obligation is to give the full hearing of the parties. At the same time, an obligation is cast to dispose of the case at the speediest, because speedy justice is also for the victims, as well as finding the accused guilty is also an important aspect for the court, because it's a specially constituted court. As per paragraph 1, 2 is, in this case there are 5 offences so and so for which accused may be visited with the death sentences. Lordship may kindly see 120B, 302, 121, 302 of IPC, 3B of Explosive Substance Act, and section 16 of UAP Act, for which it may be visited with the death sentence. The accused number 2 are examined on the quantum of sentence. They submitted as follows. There is nothing to submit on the quantum of sentence. A2, A3, nothing to submit on the quantum of sentence, nothing to submit A4, A5 nothing to submit, and A6 nothing to submit. My lord, my respectful submission, such a, my lord, a gravity of offences, such a special case, my lord, because of this, my lord, the Honorable Chief Justice of, my lord, the High Court, my lord, because of the gravity of the offences, the importance of the case, and also the important legislations, my respectful submission, the Unlawful Activities Prevention Act 1967, and also, my lord, all Explosives Act, and all, my lord, nearly, my lord, the tens of people has died, my lord, hundreds of people are, my lord, seriously wounded. So such a case that too, my lord, explosion, a bomb explosion, my lord, in a democratic and a sovereign country where, my lord, the rule of law is enforced. My lord, the duty of cast upon the, my lord, the governments, either the state or central government, to ensure the safety of its citizens, its subjects. For such a case, my lord, a foreigner conspiring, my lord, by sitting in a, my lord, enemy country, that is a Pakistan country, because this alien country, my lord, is an enemy country, because we have no cordial relations, my lord, from the time of getting an independence, my lord, after, my lord, the, particularly with regard to, my lord, the Kashmir issue, my lord, what I am trying to say, to grab, my lord, the property of this country. So, my lord, the agencies of the, my lord, the Pakistan government, ISI, is being used. My respectful submission is, so even investigation also revealed that ISI also involved in this, in training accuser number 3, my respectful submission, Ziaur Rahman, the Pakistani national. So, my lord, in that such a case, my lord, I am not finding any fault with my learned, my lord, respected advocate brothers. I can say that such a, my lord, an important thing, my lord, if security is not there, my learned friend said, my lord, that on that day, lot of, my lord, this, yes, candle march was going on. So therefore, we feared to our lives. This is a country, my lord, where rule of law is enforced. And more so, my lord, they are officers of the court. They can request the court even prior to that. They can address a letter, or otherwise they can file a petition. 13th is there. This is, my lord, 19th. 6 days are there. My lord, this is a case even for a house motion, my respectful submission. They would have brought, my lord, with the more security, not simply, my lord, the accused standing, my lord, saying that advocates, my lord, were maybe not present because of the threat to their lives. My lord, that cannot be a ground. Taking, my lord, at the juncture, at the time of appeal, no, we were not. My lord, the case is there. My lord, we are all appearing before the lordship. Today is posted for my arguments. But if I do not, definitely this court, my lord, because that's a trial court, that too, quantum of sentence, my respectful. It's not a hearing appeal. Hearing appeal, my lord, can be adjourned on the request. Otherwise, liberally, my lord, can. So this is not that such a, my lord. So therefore, my humble submission is, it was, the accused was, my lord, sufficiently hard. The principles of natural justice was followed. The provisions of CRPC was followed. My lord, in quantum of sentence. My respectful submission, my lord, the arguments of the land public prosecutor, lordship may kindly see, my lord, paragraph 4. The land public prosecutor from NIA submitted contending that this case come under the category of rarest of rare cases. Further submitted that nature of injuries, the ghastly pictures from the scene of the blast, the stories of the sufferings of the people as reported by this print, visual as well as the social media, and moved the sentiment of the whole nation, but for the accused, who has noted above, had metamorphosed into killing of machines driven by a peculiar psychopathic inclination of their minds, dictated them to kill in the name of their perverted, repugnant interpretation of religious concept of jihad. In this chart, retrieved later during the investigation, the accused discussed about Dawat as a celebration of successfully killing these many people. The accused drew their justification from self-concocted, perverted, and aberrant interpretation of religion and take pride in it. And he also relied upon the decision Muhammad Amir Hassar, alias so state of Maharashtra, where it was held that the preparation and training for the execution was as thorough as the execution was ruthless in terms of loss of life and property, and more importantly, in its traumatizing effect. this case stands alone, or it is at least the very rarest of rare before this case since the birth of republic. Therefore, it should also attract the rarest of the punishment and prayed for capital punishment. Malodi relied upon the another judgment, Muhammad Mannan alias Abdul Mannan versus State of Bihar. It was held that when a crime is committed in an extremely brutal, grotesque, diabolical, revolting, dastardly manner, so as to arouse intense, extreme indignation of the community, when collective conscience of the community is petrified, one has to lean towards the death sentence. In the present case on hand also, certainly the crime is committed in extremely brutal, grotesque, diabolical, revolting, so and so and so. The decision is applicable to the present case on hand. My lords, and we relied upon the other judgment, my lord, Beru Kalyan, SSC, so and so and so. In Dhananjay Chatterjee versus West Bengal State, Honorable Supreme Court observed that justice demands that court should impose punishment befitting the crime, so that the court reflect public abhorrence of the crime. The courts must not only keep in view the rights of the criminal, but also the rights of the victims of the crime and the society at large, while considering the imposition of appropriate punishment. There is no dispute with regard to this, said the law laid down in this decision. And another judgment, my lord, Muhammad Arif, and even also, my lord, the which judgments I prepared, this list is also there. The relevant, it is mentioned here, my lord. It was thought out insult offered to, my lord, in so and so case, wherein it was thought out insult offered to question the sovereignty of this great nation by foreign nationals. Therefore, this case becomes the rarest of the rare case. This was nothing but undeclared war. Some foreign mercenaries like the present appellant, his other partner in conspiracy, Abu Shamal, and some others who either got killed or escaped in conspiring to bring about such kind of attack, then carrying out their nefarious activities in a systematic manner to make the attack possible was nothing but an attempt to question the sovereignty of India. Therefore, even without any reference to any other case law, was held this case to be the rarest of the rare case. In the present case on hand also, A3 is a foreign national, and the rest of accused developed the mindset of the foreign nations, became enemies to the society. He also relied upon so and so, 1-2 versus so and so, the state of Uttar Pradesh, 2009. What is culled out from the decision noted above is that while deciding the question as to whether the extreme penalty of death sentence is to be awarded, a balance sheet of aggravating and mitigating circumstances has to be drawn up. There is no dispute with regard to the ratio laid down in this decision. At this stage, it is settled law to decide whether extreme penalty of death sentence or give alternative punishment of life imprisonment. One has to consider both mitigating and aggravating circumstances. On this aspect, Supreme Court in Bachan Singh versus State of Punjab held that so and so mitigating circumstances in exercise of the discretion in the above cases, that court shall take into the following circumstances. Number one, that the offense was committed under the influence of extreme mental, emotional disturbance. The age of the accused, if the accused is young, old, shall not be sentenced to so and so. The probability that the accused would not commit criminal acts of violence as would constitute a continuing threat to the society. Read 2 again. Read 2. The age of the accused. If the accused is young or old, he shall not be sentenced to death. My respectful submission. No, my submission is, my lord, lordship is only, my lord, referred to the, my lord, only the two second observation. But the second observation is not the sole observation to decide. In, my lord, in relation to first also has to see. One is, my lords, my lord, this is, my lord, 1 and 2. I'm sorry, 1 and 2. This is not emotional and etc. And the probability accused has not committed criminal offense which constitutes so and so. Probability can be reformed and rehabilitated. The state shall by evidence prove that the accused does not satisfy the condition 3 and 4 above, that in the facts and circumstances, he was morally justified in committing so and so. The accused acted under so duress domination. The condition of the accused show he was mentally defective, so and so and so. My lord, all 7 conditions, my respect. One is, my lord, they are the hardcore, my lord, the having the criminal background. My respect of the series of the blast, which has not only destructed, my lord, the Indian society, its property, and my lord, killed ruthlessly the women, children, my lord, fetus in the womb, my lord, number of deaths caused by, my lord, in the name of, my lord, the so-called what was discussed earlier, in the name of, my lord, the religion and jihad. So, my lord, this ruthless and brutal activity. In the present case on, Lordship may kindly see, was not committed under the influence of extreme mental emotional. It was committed with the pre-planning even after committing the test blast. My lord, so far as age of consent, even though the circumstances alone could not come to the rescue after balancing aggravating circumstances because their ideology is very dangerous to the society. And in so far as conduct of the accused is concerned, they are involved in several crimes of the similar nature. Therefore, there is a probability that the accused could commit the similar crime if they are given a chance of life imprisonment. So far as the reformation, rehabilitation, the court observed right from the beginning their adamant attitude, Lordship may kindly. And they are well trained as to what to do during the legal proceedings in this court. Even today also, they sent a petition through jail authorities with a false allegation. This letter shows that they have the legal knowledge only to escape from the clutches of the law by creating artificial loopholes. I am extracting 2 lines from their letter. Whatever punishment you are going to impose, we have every right to appeal against our judgment. Earlier also, they have given similar applications, asking the court to stop the proceedings. This court asked them to approach appropriate forum. They have any grievance. The accused has filed WP number 27445 before the Honorable High Court. Same was dismissed.
What is the relief sought in this?
My lord, the relief, the very appointment of the, my lord, the special court that Srinivas Rao yesterday submitted. And my learned friend also brought, my lord, the proceedings, but I will file with the written argument, my lord, what are the affidavit contents and etc. also, my lords. The accused are well tried to create artificial loopholes, so and so. Once they are tendered an apology on so and so, stating that we sincerely apologize for attributing these averments to this court for submitting a false petition. Therefore, one cannot expect any reformation or rehabilitation from them. There is no material to show that accused are justified in killing 17 persons, a quick unborn child, causing simple injuries to 126 persons. There is no material show that acted under duress, domination, or another person because of these 5 persons are members of Indian Mujahideen. Their mentality is to kill the innocent persons under the guise of jihad for a holy war. My Lord, Honorable Supreme Court, Machi Singh, my Lord, this is also your Lordship aggravating and mitigating circumstances. My Lord, your Lordship is aware the manner of commission of murder. My Lord, Machi Singh, my Lord, my respectful submission. The normal, my Lord, the IPC offences, my respectful submission, where the personal enmity or property enmity or otherwise the political enmity, my Lord, there a person is not, my Lord, the very mindset is not so criminal, my respectful submission. Here is the mindset itself, my Lord, is my Lord, they developed a conspiracy. My Lord, they are already, my Lord, my Lord, they took the work, my Lord, even the investigation has revealed that for the same, my Lord, to establish, my Lord, my respectful submission, that the, my Lord, so-and-so Islamic world, which is not this whole world, my Lord, is faith of different religions, my respectful submission. My Lord, for my Lord, many said, my Lord, the history of the, my Lord, the human mankind, my Lord, many religious flourished. All the religions are not only, my Lord, the principles of peace, my Lord, harmony, unity, integrity, my Lord, the respect. My Lord, what I'm trying to say, my Lord, my respectful submission.
Trial court judge lagane adverbs.
No, my respectful submission is, my Lord, the very gravity, my Lord, what the last, my Lord, after the last. I only bring to, I am only, my Lord, here the.
Even Mr. Mahadevan is also accepting.
My Lord,
he never opposed.
I am only legal agent, my Lord, to bring to Lordship's notice. My Lord, God has sent me, my Lord, to inform the sufferings of, my Lord, the loss of the people, my lord, the loss of the lives, loss of, my lord, even living as a dead people, even as of today. My lord, they lost their lives. So what I'm trying to, maybe, my lord, I'm telling the words maybe because the case is like that. Definitely, my lord, it's my duty as a public prosecutor to bring to lordship's notice for ultimate justice to the victims. Yes, my lord. My respectful submission is so therefore these are all, my lord, what I said. My lord, paragraph 18 is also important. My lord, not only myself, my respectful submission. In every case, my lord, the prosecution side, what well as, my lord, the defense side, they submit with regard to lenience or otherwise innocence. Coming to, my lord, all last case in, my lord, in this country. Take, my lord, lordship, my lord, the Taj attack case, Kasab's case, my lord, every, because my lord, your lordship is aware what what religions are teaching, but it should be the part of the record so that, my lord, the generations, my lord, the coming generation will come to know how the Indian judiciary, my lord, has reacted to these ruthless killings, my lord, because, my lord, men are, my lord, we are immortal, we are not immortal. So therefore, as a matter of record, my respectful submission is. So paragraph 18, my lord, I request your lordship to see paragraph 18 in the present case. On hand also, crime is committed in extremely brutal, so and so, diapical, revolting, so and so. There is motive to the accused persons to commit this crime under the guise of jihad, and said crime is anti-socially abhorrent nature. Crime is enormous in proportion, causing multiple murders of 17 persons and death of cute born child and injuries to 126 persons, and the all victims are innocent. They have never might have been these accused persons. There was no provocation for commission of this crime. Therefore, the Devo decision is applicable to this case. My lord, Ankush, Maruti, Shinde versus, my lord, this is also with regard to lawlessness, weapons used, conduct of the accused. My lord, the imposition of death sentence was discussed. Another judgment, paragraph 20. My lord, the Mahesh versus State of MP. My lord, this is so and so and so. Reduced the death sentence, the Honorable Supreme Court observed, my lord, para 6 is relevant. It will be a mockery of justice to permit the accused to escape the extreme penalty of law when faced with such evidence and such cruel acts. To give the lesser punishment for the accused would be to render the justicing system of the country suspect. The common man will lose faith in the courts. In such cases, he understands, appreciates the language of deterrence more than reformative jargon. In addition to this, one may also take note of observation of FX court in the matter. Dhananjay Chatterjee, in our opinion, the measure of punishment in a given case must depend upon atrocity of the crime and conduct of the criminal, and also defenseless, unprotected state of the victim. Imposition of appropriate punishment is the manner in which courts respond to this society's cry for justice against criminals. Justice demands that court should impose punishment fitting to the crime so that court reflect the public evidence of the crime. The courts must not only keep in view the rights of the criminal, but also rights of the victims of the crime and the society at large while considering the imposition of appropriate punishment. So the present case also, in the interest of justice from any angle of the society, death punishment is inevitable. It was held in so and so, my lord, Uwali Singh versus, my lord, so and so case, by paragraph 22, my lord, Sangeet and other versus state of Haryana, my lord, almost the Honorable Supreme Court, page paragraph 23, Om Prakash versus state of Haryana, settled about the death sentence, how has to be. Paragraph 24, Mohan and others versus state of Tamil Nadu, and Bachan Singh and etc. My lord, these are all, my lord, the ratios laid down, and also, my lord, the observations, the important observations of the apex court of this country, my lord, by taking into consideration the nature of the offense, gravity of the offense, my lord, the serious consequences of this, the acts of the crime, and also, my lord, the effect not only against victims but society at large. And, my lord, these accused 1 to 6, 2 to 6 who are present before lordship, my lord, they challenged, my lord, the very sovereignty of this country, my lord. We the people, my respectful submission is, we are living, my lord, in a democratic country, that too protecting our sovereignty, my lord, by maintaining my lord, the peace in the country, which is utmost important for, my lord, the well-being and, my lord, the welfare of the people of this country. Once, my lord, this aspect is lost, there will be anarchic society and no one will live freely and nobody's lives and properties are secure, my lord. So therefore, my respectful submission is paragraph, the last one, my lord, after the judgments, my lord, I may be read paragraph 26 and 27, my lord, I conclude. In the present case, only mitigating circumstance,
26, right?
yes, is the age of the accused. But the only one mitigating circumstance cannot wait against numerous aggravating circumstances. It hardly can tilt the balance in favor of the accused. The crimes committed by the accused are barbaric, are inhuman, diabolic. In my view, the accused are shown extreme depravity with committing the twin blast. The court has already given a finding that offense have been committed with previous planning and extreme meticulousness after conducting test blast. Moreover, the accused number 3 is a foreigner and the other 4 accused are trained for foreign country in waging war against this country. All accused are having similar mindset. Their ultimate objective is to kill innocent persons in this country, thereby challenging the sovereignty of this country. This court also observed everyday accused, they felt that they are heroes and committed heroic acts. In this case, accused did not act on provocation, nor did they act in spur of moment, but meticulously executed, deliberately planned crimes in spite of understanding the probable consequence of their act. Death sentence shall be the most appropriate punishment. This court considered the pre-planned and barbaric nature of the crime, the diabolical manner in which it was committed, the extreme brutality involved as aggravating circumstances against accused. I am of the sincere opinion that the maximum punishment will send the right message to the society and also to the like-minded persons to show leniency or mercy in case of such heinous crime and upon the accused who have shown no repentance or remorse after exhibiting extreme depraved mentality. Therefore, this court has to award the death penalty to the accused yet they do not deserve any sympathy for the offense. 120B 302, 121 302, my lords, all the offenses which 16 and 3B of explosives, my lord. So insofar as the disposal of the property, so and so, alternative condition is unquestionably foreclosed. So sentence order, my lord. This is what, my lord, the sentence part, my lord, nearly 10 pages of, my lord, each and every, my lord. So I read, my lord, the important one, my lord, important the first. Paragraph 29, accused number 2, Asadullah Akhtar, sentenced to death for the
No, he wants to read. That's what he sought permission also. Read.
The accused number 2, Asadullah Akhtar, is sentenced to death, further sentenced to pay fine of 10,000 IDSC for 1 month for the offence punishable 120B read with 302 Indian Penal Code. He shall be hanged by neck till he is dead. He is further sentenced to death, further sentenced to pay 10,000 so and so IDSC and so for offence punishable under section 121 of Indian Penal Code. He shall be hanged to so and so. He further sentenced to life for and further sentenced to pay 10,000 in default so and so for 1 month simple imprisonment. IDSI in default simple imprisonment for 1 month for the offence under section 121 of Indian Penal Code. He is further sentenced to imprisonment for life. So accused to pay 10,000 so and so for the offence under section 122 of so and so. He further sentenced to death to pay 20,000 for each so and so IDSC for so and so 302 for each count for the offence punishable for 302 read with 34 of so and so 34 2 counts. He shall be hanged by so and so. He further sentenced to undergo imprisonment for life and 20,000 IDSI for 1 month and offence punishable 307, my lord. The other one is rigorous imprisonment for 10 years, my lord, for 316, my lord, aborting, my lord, the kick, my lord, unboard, my lord, chain. 316 read with 34.
and the other one is, my lord, the 436. My lord, this is for 10,000, and also life, my lord, 436 is, my lord, my lord, file, my lord, causing a fire, my lord, destroying. Is further sentenced to undergo imprisonment for so and so and so, IDSI so and so, 201. My lord, this is imprisonment for 7 years, and another one, 466, 109, 7 years, and another one, 474, read with 109. My lord, this is 7 years, and the other one is section 3 of Explosives Act, my lord, sentenced to death for the offense punishable 3B, he shall be hanged by so and so, imprisonment for life. And the next one, my lord, page number 711, is further sentenced to death, further so and so, 3 of Explosives Act, 34 of so and so, he shall be hanged so and so. My lord, this is all my respectful submission for every, my lord, the penal section, the particular, the accused, my lord, with regard to the, my lord, the charges, the punishment is given. Ultimately, the maximum punishment is the death. My lord, the minimum is, my lord, the 7 years and etc. My lord, that is 2 years also. My lord, with regard to public property damage, my lord, Act read with 34, 2 years, and also fine. So this is, my lord, all my respectful submission. It's all nearly 10 pages, and I'll read the important one. A3, my lord, A3.
A3 page 30, paragraph 30.
Yes, madam. Page number. Yes, madam. A3, Ziaur Rahman. Because this is specific foreigners act, you know, he is a foreigner, that is reason. So and so, my lord, he is also under, my lord, I'll read the offense and punishment, my lord, need not read. 120B, 302, my lord, the death penalty. My lord,
already
yes.
We have list.
And I'll just draw one paragraph for every, the accused, for my satisfaction, my lord. Yes, ma'am. Paragraph 31. 714. Accused number 4, Mohammed Tazeen Akhtar, is sentenced to death, further sentenced to pay fine of rupees so and so and so. Allowed all the same offences of 120, 121, 122. Allowed all this. And after A4, allowed accused number 5. Yes, paragraph 32. Page number 717. Every paragraph is with reference to one accused. The quantum of punishment is. But Mohammed Siddibapa, so and so and so. Same sentence to death, further sentence to pay 10,000, IDSI for 1 month for the offense so and so, 120B 302, so and so and so, my lord. And next paragraph, 33, my lords. Page number 720. One accused. The accused number 6, Ajaz Sheikh, my lord, so and so, sentenced to death, further sentence to so and so and so. And my lord, this is all. So therefore, the finally also, it is felt no surprise, my lord, next victim compensation, my lord, paragraph 34. It is brought to my notice the grievously injured persons did not receive sufficient compensation from the government. My lord, hence sufficient compensation may be granted for them. In this case, 126 victims, out of which 78 are victims who sustained grievous injuries, are entitled to compensation from District Legal Service Authority. The District Legal Service Authority is directed to decide the quantum of compensation to be awarded, and the scheme referred to subsection 1, section 357A of CRPC. The fine amount paid by the accused also can be utilized for compensation. The list of victims grievously injured are entitled for compensation. My lord, in this particular case, my lord, as far as my knowledge is concerned, I think, my lord, the fine is not paid. Yes, sir. So even, my lord, the victims will not receive the fine, my lord, that they have not made any application. My lord, the city.
Without paying fine, without filing receipt, they will not number the appeal.
Yes.
Is it not?
Fine, because the huge amount there, my lord, huge amount is there. My lord, it's not a, my lord, in a bar of death sentence, it's not a bar in death sentence. As, no, it's not a bar for filing appeal in death sentence.
Without file, they can prefer appeal.
As far as my little knowledge, legal knowledge and wisdom is concerned, your lordship is rightly posing the question.
Itil another, special page. Objection this problem.
Lordship may these details can be furnished by the registry. My legal common sense, because right of an appeal is a death sentence. Right of appeal in a death sentence is a right.
Common sense anakandi sir.
Yes, legal, I say that.
Legal. చూడండి లేదు కదా ఇందులో అబ్జెక్షన్ అయితే తీసుకోలేదండి తీసుకోండి సరే anyway
We will be invited my lord hearing after and my respectful submission. My lord, the victim's compensation is concerned, my humble submission. The court below, because of my lord, the powers my lord, are less my lord, used by the court below, because it is referred to legal service authority. My lord, what exactly my lord, that is not my lord, what the compensation is. My humble request for consideration is the my lord, the 17 persons died and nearly 126 my lord, the victims. My lord, the 78 out of 126 my lord are seriously sustained grievous injuries. My lord, my humble submission, this court got ample powers under 357A, because my lord, the justice, my lord, justice means it's not only punishing my lord, the accused, but also my lord, to pay the proper compensation to the my lord, the innocent victims who are my lord, the poor and middle class people. My respectful submission is on the date of explosion, 21st February 2013, my lord, the people, my lord, these hundreds of people on a public road, 107 bus station, A1 Mitchell Center, my lord, these are all middle class, my lord, the poor people with my lord, the meager incomes. All of them, majority of them are migrators to the city for the sake of my lord, the livelihood. So my respectful submission for that, before conclusion of their arguments, I will submit the judgments of the apex court as well as the division bench of the courts, my lord, to increase the victims, my lord, the compensation. My lord, I pray this honorable court to confirm my lord, the death sentence for A2 to A6, and also my lord, confirm the judgment of the my lord, the trial court judgment for A2 to A6, and I pray this honorable court to exercise the powers 357A and pay the more suitable deserved compensation, even that will not my lord, compensate the lives and liberty and my lord, the health of these are all death people, the my lord, the dependents, and also injured, seriously grievous hurt, and also my lord, the simple injured. This is my respectful submission.
Judgments.
And judgments are concerned. Well, 357. 357, a lordship can.
Citation.
357,
there is no need. We have even scheme also.
Yes, that is
scheme, etc.
Monday is. Which is available.
First one, first citation.
What is the first citation? Tell the judge. Asmal Kasab.
Citation first.
2012 9 SEC.
9 SEC, page number.
Yes, minute. My lord, page number.
Page number 1.
One. Yes, minute.
This is Kasab's case, right?
Yes, yes.
Which paragraph is
Minute,
written?
I have written, minute, 1 second. Conspiracy to wage war.
Paragraph number?
Paragraphs 267 and 315.
267 and 315.
My lord, the head notes.
You want to read or?
Head notes. For a few minutes.
Head note కూడా అక్కలే ప్రిన్సిపల్ చెప్పండి.
Principle, my lord. Yes, the principles, my lord, in a conspiracy, my lord, the observations of this court, my lord, to conspiracy to wage a war, my lord, the relevant time, my lord. with regard to one surviving Pakistani, my lord, that is the Kasab, how he revealed, my lord, the conspiracy hatched by them, my lord, in Pakistan, and particularly, my lord, with the help of the ISI, that what was stated, and the very confession of the accused before the, my lord, the judicial officer under 164, that was given more credence, more trustworthiness, my lord, particularly to that statement, and the Honorable Supreme Court relied, and that the statement of each and every bottom of that statement corroborated with the investigation in that case also. The eyewitnesses, the circumstantial witnesses, and therefore, my lord, my respectful submission is, in a case of conspiracy, generally, my lord, these terror plots, particularly the terrorist conspiracy, my lord, because these are all intra-countries conspiracy. So this is all hatched in secrecy. So there will be no direct evidence, my respectful submission, because the very conspirator is hiding in Pakistan and using all these, the other 2 to 6 with pre-planned, pre-knowledge, by motivating them with the consent of these A2 to A6. So, my lord, these are the paragraphs, my lord. And my respectful submission is, and the other aspect, my lord, my learned friend, before going to the confessions and voluntariness, my lord, confessions and voluntariness. Paras 517 to 521.
Same judgment.
Same judgment.
Paragraph number
517 to 521.
This is on conspiracy.
Confessions, voluntariness. And parrot 529 also, my lords.
529 is also.
Yes. And other one, conspiracy between accused and his companions, recovery and confessions, paras 532, 534. Conspiracy between accused and companions, recovery and confession, paras 532, 534, 606 para. Next, waging of war, not used in narrow sense, my lords. Paras 545 and 546. Death sentence for guilty. No. Waging of war, what amounts to terrorist act? 120, 121, 122 of IPC was discussed. Death sentence for guilty of waging war, committing murders, conspiracy, behind attack. Death sentence for guilty of waging war, committing murders. Paras 563, 564, 571, 573, 577, 579, 585, 586, 606. And the other one, Muhammad Arif versus State of NCT Delhi. Muhammad Arif,
Citation.
2001, 8 scale, 328. Muhammad Arif? Yeah. Yes, ma'am. This is paras Red Fort attack case, my lord, the army installations. 2011, no need, my lord. I'll only submit, my lord. I'll give in writing also. I don't trouble, my lord, because I'm not reading the head notes also, just only the gist. I don't trouble, my lord. Para 74, 76. This is Red Fort case. Muhammad Arif versus State of NCT and Delhi. My lord, this is discovery of evidence, what its evidentiary value was also discussed. Formal arrest of accused, no discovery statement recorded. There is not anything wrong with the discovery, even if the information was not recorded. That is what and another one, telephone conversation is a proof of complete link between the appellant and crime. Telephone conversation. Para 34 to 39. Yes, ma'am. And another one, parliament attack case, my lord, Muhammad Afzal
Citation.
versus State of NCT and Delhi. This is 2005, 11 SCC, 600. My lord, in this particular case, my lord, even earlier also I mentioned is our own, our lordships of our state judgment and other also. My lord, every aspect of terrorist act, waging war, section 120 of IPC, persons not bearing allegiance to government of India, para 272, 275, 285, para 287, 266 and 267, 282, 289. My lord, very elaborately. My lord, more than my lord, 150-page judgment, the conspiracy elements, what are the elements of the conspiracy for the offense? What are the conspiracy for proof of nexus with the fact and interception of the phone calls? It is not necessary to do a single act, my lord, for doing a conspiracy. My lord, only all has to participate. That is not, it's clarified, my lord. That is an important. Other thing, my lord, my learned friend, my lord, with regard to representation of accused to be represented and the procedure followed before the trial court. My lord, all are represented by the lawyers, all the legal, my lord, the due legal representation as if provided to Indian citizen was also provided to Indian accused, I can say, of this country was also equally provided without any discrimination. Well, the Court of Criminal Justice of this country being a civilized, the Constitutional Court of Criminal Justice followed all the, the general principles of law, everything, framing of charges, all the quantum, everything charges, examination, chief opportunity was given. And my learned friend said, accused number 3 being a foreigner, and also, the international covenants, myself being a political science student, being the international covenant on civil and political rights. There are nearly 50 articles in that. Almost these 50 articles that embody, this is the international covenant, with the participation of all the civilized, democratic, and republic countries of the world. All the people of the world framed certain for the welfare of the world people. So according to that, there is a with regard to the relations of two countries and also the rights of the foreigners. And my respectful submission, Article 10, 11, 12, 13, 14, 35, 36, 44, 45, which deals with the human aspect of the political and civil rights, even if rights of foreigners in prosecution in another country were scrupulously followed. An opportunity was given as if given to the subjects of this country, the citizens of this country. And my learned friend has also referred Vienna Convention. Vienna Convention, it's a treaty on the rights of the diplomatic rights of the countries. All the diplomatic rights we followed. Even we got the information from the Ministry of Justice and FBI, but exactly the role. Every point of the evidence is collected from the world, not from the country, in this country. Even the proxy servers which they used from different destinations of the world, that was also the information was perfectly gathered. So there is no any violation of the Vienna Convention, as my friend argued, 1963, International Covenant on Civil and Political Rights, and all the articles of the Constitution of India, which is equally given to the citizens. That is the beauty of the Indian Constitution. We provide equal rights to all, even the foreign citizens while they are in this country. So therefore, here is a liberty, freedom, everything, legal aid, and even the court wants to, the state wants to spend the expenses for their, even the prosecution, my respectful submission, even in court, the state wants to provide the legal assistance, legal aid also at the cost of the state. The public exchequer, my lord, there is a people money. Though the people are killed, Lord, that is, my lord, that taxpayers, civilized system. So therefore, my respectful submission, my arguments for all these days, conspiracy, everything, all penal offences, my lord, of IPC 120B, 121, 122, all, my lord, by respect to 302, 307, and UAP Act 16, and other the relevant, my lord, fund, terrorist fund, and explosives act, and foreigners act, public property damage act is perfectly proved. There is a clinching, cogent, trustworthy, reliable, and every evidence is there. So therefore, they are deserved for the death penalty. Then the justice can be done to the victims and the death people. This is my humble submission for consideration.
Mr. Chandrasekhar, A4, we will say you have argued. ఏమైనా ఉందా ఇంకా స్టార్ట్ చేస్తారు ఏముంది ఆల్రెడీ చెప్పారు A3 and A4 సేమ్
స్పెసిఫిక్
చెప్పండి. మైక్ యూజ్ చేయండి.
The Delhi Special Cell arrested on 22 March 2014. A4.
22nd
March 2014. In crime number 54 of 2011. Delhi Special Cell. Along with A3. Their recorded confession statement of this A4 on the statement. This crime came into knowledge of this investigating officers. NI office.
Confession of A3.
A3 and
A4.
On production warrant produced before NI Court, Hyderabad. And taken into police custody on 24/5/2014 to 9/6/2014. In the meantime, the investigating authorities conducted TA and IED demo and scene reconstruction, TA and these things. To prove the case, prosecution has examined important witnesses are 54, 55, 56, 57. Abdul Lapur met. Since those witnesses are the main allegation of prosecution on A4 is he taken shelter at Abdul Lapur met.
He
taken shelter. And meanwhile, connected Ricky and purchased cycles, and he was one of member in planting one even cent.
volume 2. Page number 383.
Of volume number?
2.
Volume 2. Page 383.
383.
Let me continue. What is page 383?
383 is the wife of one. The shelter place taken at
54.
54 is the wife of 55.
Correct. So you are reading 54 deposition.
54 deposition.
No, sorry. ఆర్కిడిసి ఏ4కి చంద్రశేఖర్ గారిని ఎప్పుడు అపాయింట్ చేసినట్టు 10 ఇయర్స్ very short chief examination and short class examination.
Given the key and given key and out to the one day the first week about 2001 student asked me to show the shadows for 10 minutes. And also informed that my contract owner that I handed over the key to the said person. I cannot say in the confirmation, she stated, I cannot say the name of designation of the police officer who recorded 161 statement. Then I did not state any in my 161 statement or 164 statement of during PA period, the name of A4. So also I did not state the descriptive particulars of person in my 161 statement and 164 statements. It is important point to
or during
this is not corroborating the previous statement without any specific entity remarks. Identifying is suspicious and doubtful identification. Yes, 156.
PW?
155, 56.
55 or 56?
PW4 husband. PW4 husband. PW
55 కదా
55.
55 వెంకటేశ్వర
వెంకటేశ్వర.
Cross or chief?
Cross submission.
I did not identify A2 and A3.
I did. It is
not Japan. I can't say the date, time, and dress worn by A2 to A4 when I saw them in our colony. It is not to suggest I did not state in my 161, 164 or TIP that the very same person who had taken the rent on first day was the person who handed over keys on the date of the blast. Next.
56.
56 over Kaja Pasha.
389. Page number 389.
Auto driver. Correct. He is maintaining auto. At that
by profession.
Right.
He stated we don't maintain any record for selling away the cycles. I am not holding any license to the business of at Jumanat Bazaar. It is true that immediately after hearing about the blast sooner, I did not give any complaint to the police station. I never went to any police station, particularly NIA police concerned with this case. Police are not examined. I have no record to show that I used to purchase spare parts of cycles and after assembling, I used to sell away them every week in the Jumanat Bazaar.
పెద్ద పెద్ద మాల్సే మెయింటైన్ చేస్తారు రిజిస్టర్ స్టార్టర్ రిజిస్టర్ సైకిల్ పార్ట్స్ అమ్మాయని ఏం చేస్తారు
అకౌంట్స్
మాల్స్ ఉంటాయి కదా దే హావ్ టు మెయింటైన్ సర్టన్ స్టార్టర్ రిజిస్టర్స్ దే ఆర్ నాట్ మెయింటైనింగ్
దే మెయింటైన్ అనాథరైజ్డ్ అకౌంట్స్ అవన్నీ చూపించాలి
ఆఫ్ కోర్స్ యూ హావ్ టు డూ యువర్ జాబ్ యూ కెన్ డూ అవర్ జాబ్
ఇట్స్ 57
PW 57 who is it? Sheikh Ismail. Puncture shop.
He also one of the seller of bicycle. He did not set any descriptive particulars of any of
A4. Both are the common arguments.
He did not state I did not state in one statement that I have shops treated market specifically.
హైలైట్ మీరు అండర్లైన్ కూడా చేసుకున్నాం ఏత్రికి చెప్పినాం
His identification is not corroborating with the previous version. PW 58. He is a seller of pressure cookers. Pressure cookers. It is true that I did not state before the magistrate as to the manufacturer company of pressure cooker. I did not state in one statement one day prior to the bomb blast, 3 persons came to our shop and 2 out of 3 persons were standing outside the shop at a distance of 6 feet to me. And one person asked me to sell 2 cookers of same big size, and then the said person was talking in some other language which does not belong to South or North India. And then we packed 2 cookers of big size, and they were local for life college students, but there were no college nearby. These 3 customers were unusual to our shop because we normally get lady customers. The reason for
వాళ్ళు కుక్కర్స్ కొనద్దాం సరే
reason for remembering, he taken reference of reason. I do not know the designation of person who served the person to me and did not ask his ID card before 164 statement. He is a protected witness without proper verification, proper entity cannot examine. His statement is without verifying his identity, 164 is recorded.
Yes.
He not maintaining any record of customers. I cannot give the details of items sold on the day, the names and customers therein. The pressure cookers are we sell on warranty.
Warranty period.
Warranty. Because that is essential for the issuing of receipt. It shows it doubtful. Selling is doubtful.
వారంటీ లేదా ఈ కుక్కర్స్ కి?
They police have cited him to stood as witness without any record.
He is a planted witness.
Planted witness. It is true that till I gave my 164 statement before the magistrate, I did not tell about the sale of 2 pressure cookers to the persons who came to me on 20/2/2013. He secretly kept the information in. (159) PW 59. Meru ILF.
ఈయనేం చెప్పలే కదా A4 గురించి. PW 59. మెరుగు అయిన
Prosecution is the only eyewitness.
ఓన్లీ eyewitness కానీ ఈయన A4 గురించి ఏం చెప్పి
In entire case, there is no eyewitness. Witnesses are registered witnesses.
ఒకటి వన్ సెంటెన్స్ ఉందండి. ప్లీజ్ కమ్ టు 403 ఆఫ్ ది వెరీ సేమ్ పేపర్ బుక్. లాస్ట్ సెంటెన్స్. బట్ ఇన్ ది సెకండ్ టైం on 9/7/2014, I identified A4 as I was permitted to go near and point out A4. ఇది ఒకటి చెప్పాడు. Against A4.
In the TA period.
TA period. Third, second TA period. Second అంటుంది కదా.
This man did not identify.
First time. అదే సెకండ్ టైం he has identified. A4, correct. So he is not arguing for A4. So this is one statement he made.
That's PW 66.
66 ఎవరు?
He leased the parking of Malakpet railway station.
Malakpet contract.
424 page.
Ahmad Aif.
Ahmad Aif.
ఈయన కూడా ఏం చెప్పి
He did not give any documents to police.
A3 argument. A3 argument. Nothing against A4. Right?
Yes. PW 67.
67. ఆడబోయిన వెంకటేష్.
He also not produced any document, valid document to prove he is a contractor of railway.
Mine FSL already over. Subramaniam already over. PW 82.
PW?
82. Asif with 1. 512. Yes, he is a cousin of paper. Examined for prove the fake ID. He is not supported the person. And 83 also later of 83. And PW 110 is a handwriting expert. They taken exhibit to P 325, 326, 330.
Exhibit?
325 and 326 to 334.
2, 3?
34. In the cross examination, I stated, I did not mention the same in my opinion. Specifically, it is continuation of my opinion. It is not to say that he given on his opinion on basing on the reason of which continuation of opinion and mention in the reason that I followed characteristics features of the handwriting while examining the documents, but I did not mention the same in my specifically in the continuation of my opinion. The opinion reason is not stated in his opinion. He tried to improve in the cross examination. Without reason cannot be laid. His opinion. And PW 116. Because CC JC plus CC footage hand over to the NIA. That is exhibit P 337. P 337. And MO 171. 170.
171.
170 and 171. on 25/5/2014. Page number 693, volume 3. I not given any request to the NIA police to show I am working at TSC Brothers. It is true that it is mentioned in SB 337 that on 21st February 2013 evening before the pit bust took place, two suspects were going towards the scene of offense with a cycle and one suspect coming back without cycle. Both the suspects wore cap and black color. Backtrack video was captured in CCTV, JC bus and electronics, but due to the poor okay. PW 118. Punch witness. User Rambabu. Page number 700.
Page number?
700.
Next one. 3. $900. 700, sorry. 700.
It is true in disclosure state Panchanama, where admissible portion of 338, there is no mention of NIA officials came to our office and they took us from our office, Kosha Mahal to NIA office, Begumpet initially, and then from there were to Hakimpet CRP camp office. And also there is no mention of descriptive particulars of the vehicles used and officials of the NIA police. I did not make any signature on entry list of the CRPF camp.
Also for response, please.
If we to say, I did not know the number of NIA police and CRPF police present there and that when and where accused were arrested and since how long they were in custody. With the declaration of NIA officer, the writer and constable type of the Panchanama including SB 338 to 390. It shows it is not one statement. No opportunity given to the accused to talk to the alleged detainee to know the way when arrested. On direction of police only, that is drafted. PW 120 under secretary. PW 120. This the secretary it is regarding sanction. And PW 123 is the electoral officer. He stated used voter card is a fake. తారీఖ చేస్తాం TA period. PW 132.
130?
132. This is our Telangana district collector. He sanctioned prosecute under the ES Act.
Of A4. A4.
A4. PW 134. Mukherjee.
130.
He taken. He is an investigating officer. And exhibit P 401 73 marked regarding 3 and 4. PW 135 is a investigating officer who examined the important witnesses 56, 57 and 61. Prosecution failed to prove the circumstances and alleged instances, circumstances are no way concerned with the alleged incident. After scene reconstruction, the TA period, all things is done. That is a scene reconstruction without taking proper care. All media exposed the visuals and photographs over all over India. That caused prejudice and violated his rights. He is innocent. Maybe set aside the vote for that.
Next question. According to him, you have not paid fine without.
Penalty.
What is the provision?
I filed appeal, madam. Appeal.
They have not insisted for fine.
No.
Proof of fine. So according to, there is no need to pay fine. Death penalty. Is there any provision or law? No, we are asking you academic. He has raised an objection.
No. Previous sentence. The very manner in which it drafted. Fine convicted to death and then pay a fine. Where is the question of paying a fine after death?
No, that we will concern Mr. Malcolm to prefer appeal. Is it not compulsory to pay fine?
Prefer appeal in general cases.
Correct.
Or even in life imprisonment cases. Must.
Death case.
But here it is, once he has death, suppose I don't file an appeal. Within 3 months, reference is over.
So therefore, you have filed appeal. Therefore, we are asking you without fine, how you have filed appeal?
No, not how I have filed. I have filed appeal. It was numbered.
They have not taken any objection.
No objection was there. Staff.
According to, there is no need to pay.
No need. Because in death sentence.
Are you supported by any judgment?
I will.
Anyway, we will also.
That is actually a very conspicuous point, but the less important.
Correct.
Because I don't think there will maybe any judgment also.
But it is a technical point. He has
but the technical point is, once suppose I don't prefer an appeal. After 3 months, if it's confirmed, what does the High Court do? The High Court will fix it. And he will be High Court. Unless and until he files an appeal before the Supreme Court,
or pardon by president, governor, all these things are. But suppose he does nothing.
Who has to fix the date of hanging?
High Court.
High Court or
It's called
refer trial? So under
refer
360.
trial is the refer trial. The Sessions Court writes a letter to the High Court that I have given that sentence.
It has to be confirmed. For confirmation, it was referred.
It was referred.
And according to High Court, has to fix the date of hanging.
Yeah, if no appeal is filed, that is section 366 is this kind. The referred offence is done by the sections.
So in appeal, either we will confirm or set aside or modify.
And 368, 368 CRPC says where a death sentence is rendered and within a month, if the person appeal, then the appeal and the appeal should be disposed of.
Correct.
367 says that if the High Court finds any flaw in the judgment, which are apparent on the face of the record, High Court can even have discretion to remand back. Because if the sentence is not written properly. Or in a case of 307, if the Sessions Court gives life imprisonment, then I think what happens, my lord, if there is some error, like error, in this case, the first day I argued, that was the point I argued. That is, accused was charged under 120B, read with 302, 307, all affected first charge, kindly see. But they were convicted for 120B, read with 302, 302, read with 34, 2 deaths for the same. And secondly, breaking the death sentences. That is, for unborn child, again, death penalty. How can it be? See, blast is only one. In one blast, whatever happened, happened. There can't be different for actually 316 applies. 316 where it applies if manslaughter is proved. That is, if a lady is pregnant and somebody wants to kill her or kill the fetus, then only it attacks. It does not attack in a bomb blast case and all. It can't be. Because we don't know who will get in. This spur of moment, something happens. We don't know what will happen. Some people may die because the splinters struck some tin shed and all. The tin will fall on somebody's head, it will cut the neck also. We don't know how the effect goes. So 316 cannot be applied. 307 cannot be applied. 307 also cannot be applied. The longer the entire thing is, my lord, even I never say, rather I never argued on the basis like in ordinary 302 cases, is a very poor person having small children. No, I am not. I never said. This is a case where on one angle we have all the sympathy for the people who are our people. All the sympathy for those injured and disabled became permanent disabled also, some people. But on the other hand, my contention is rule of law should be followed. Now, the blatant errors I have already pointed out in the judgment, Lord. The learned judge says 65B cannot be applied in this case. This cannot be applied. Nothing can be applied to any answer. It's something unusual. This was not expected. No. And even sentence hearing, my lord, just now here, so it will be fresh. I will come from the reverse to reverse. That too. Now, one is, my lord, when the sentence is from. Every time, at every stage, I have been observing his argument. He says accused could have objected, accused could have filed a petition to say cancel the, or to say that confession is illegal because it is in a different case. Why should I file? Constitution doesn't exist. Why should I file? And no prejudice is caused. So much of prejudice is caused. And added to that, my lord, even on sentence hearing, just now he said, few minutes back, that accused did not say anything on sentence hearing. They gave a big letter against complaining against him and don't give the judgment. We know that you are going to convict us. That's the, and that certified copy, it was given to me for after 3 months of judgment, my lord. This is all. Every time my junior Satish goes there, he will be just asked to get out. Don't come here in the section. We will not comply the CA. Do whatever is like. Is it the way, my lord? After 3 months it was given. Then I thought I kept it. I will find because it's a certificate. And another thing is, accused might not know the exact procedure to proceed against the judicial. And I did not, they did not, they asked me, you file. I said, I will not file. It is between you and the court. I have nothing against that individual or the court. My duty is to see that rule of law is followed.
To conduct the case, that's all.
I am only concerned with the papers which is given to me. Out of that only, I have to see your result. This fairly, that's the, it's not that I don't know how to make a complaint. They went on writing something, a bunch of complaints. Well, tomorrow I am going to file. Bunch of complaints, even Supreme Court they have filed. They are sent from the jail. Every time, whatever the behavior, alleged behavior, whatever it is between accused, I thought, I only said it is between accused and the court. If they are arrogant, definitely some reaction may be there on the other side. But how do I and what do I do? I never did anything. I kept silent. I never said that you write like this, or I never said that you can do like this. Why should I say? It is not my, it is not your duty. It is not at all my endeavor. My endeavor as an advocate on record is to defend. He has given me some case. Sir, you please defend me. He has given the bundle. I have to defend from within the bundle.
Not making allegation against the officer.
No, I can. How can I can make if something is addressed to me or if I am affected. Equal opportunity was given. That's the reason I was starting itself. I was telling my lord, I have cooperated maximum in the given circumstance. It's a very difficult circumstance. In fact, my lord, similar case, last cases where we examined 278 witnesses, their lordship was there. Their lordship was the person who read that the judgment, my lord. Everything went on, they were convicted. But never such things happened. Here, without passing an order that it should be in camera, the learned trial court never allowed anybody except me, Shekhar, and my junior Satish. Another junior comes, he said, no, get out. What place? There has to be an order of in camera. Even if in camera is there, who is prohibited? Any third person or any person related to that case or interested in that case. We are officers of the court. Whether he is a junior or senior, what does it matter? Nobody was allowed. The నిర్బంధంలో ట్రయల్ చేసి నాకు షుగర్ వచ్చేసింది తిండి తిండి I don't go so far. And nothing is it is after the gate, it is 1.5 kilometers inside. And every time checking my vehicle with bomb squad. These are all the harassments. I complained. He said, I can't do anything. You do whatever you want to do against NA. అంటే వాళ్ళతో కొట్టాడుకుని ఏం చేయాలి సార్ దేస్తే हमारा ड्यूटी सब हम कर see in these given circumstances in fact my lord I know everything is being recorded and everything is a fact I am speaking my lord my colleagues can give affidavits on that and I cannot shout it out. I cannot what I can do. So I thought I will just do my duty of perseverance. And if that honorable judge says that, no, this is irrelevant question, I may stop. As far as I am asking relevant questions, I cannot be stopped. And your lordship has seen in the cross-examination, everything I asked, it is true, my lord. Even the IOs. One should, this will be scrutinized by the High Court. The learned trial court judge did not feel that, I think. Either way, conviction or appeal will be there, my lord. It will be scrutinized by a bench. All these things are there after Supreme. Now, kindly see the very judgment, my lord. Anyway, sentence order, my lord. There are 29. First sentence, my lord.
Paragraph number?
On internal page 16, my lord. After the judgment. Internal page 16. First 29, item 29. The accused number 2, Asadullah Akhtar and Hadi alias Sabres, is sentenced to death. After death, there has to be only a full stop. There can't be, he shall pay a fine, he shall further undergo what it is. When you are giving it a capital punishment for that offense. And further sentence to pay fine. There cannot be a further sentence of paying a fine. When you are hanging him to death, where is the question? After death, can he come back? And again he says, you are in default to pay further 1 month. Simple. After that, he will come back again on the earth and he will be in Chadapalli jail. What is this meaning? Wherever. This is the exact point I argued before Justice Nagarjuna Reddy bench when this appeal came up for
admission.
The very thing, my lord, it's open, my lord. I am not lying anything. The learned judge said, who wrote this judgment? What is this? After death, you ask him to pay a fine. If he doesn't pay, you will another one bear from him. So what I say, this is again methodology of copy and paste. Like in other cases, he got a this is exactly happened, my lord. It's a death sentence. And this sentence should be, my lord. In fact, if your lordship sees other Bachchan Singh case, Manoj Kumar case, all this your lordship is dealing with. Kindly see, my lord. It will be the case is convicted, sentenced to death. And he shall be hanged until death. Even in so many movies, we see that the officer will break the nib also. For this offense, where death sentence is. For other offenses, okay, he is sentenced for 2 years, 3 years, for arms act 5 years.
The officer will break the nib.
No, that is the showing the all the movies. All so many movies. Justice Chaudhary and all and drama.
Movie kaadu kada.
Why I am telling is, why I am pointing out this aspect, even in Supreme Court, the lordship, where an offence is punishable with death, he is punished to death.
Full stop. After full stop.
Full stop. It is only a difference between full stop and comma. Here he says, and further sentence for the same offence.
Will concern me.
And apart from this, my lord, all the death sentences were passed like that only. And he said, these are fine, you have to pay the fine as a compensation. I will come to the compensation. When the charges are framed, there is absolutely nothing in charge to say that so many died, so many injured, so many debilitated. Kindly see the charge. Nowhere it is. Charge is only that you belong to Indian Brigade and you committed terrorist act, thereby you blasted. In the charge, by the time the charge is framed, already the court has a clear picture as to how many dead, how many injured, how many debilitated. And if your lordship Now, just now he said 357 compensation and all this, this sort of an interpretation, my lord, under the sentences. Sentences when I come, my lord, I'll take. First, I will take this death sentence only. Now, this death sentence, first charge is 120 be read with N. And the second charge, chart. I have given a clear chart, my lord. Your lordship can take my arguments, my written arguments which are filed.
Written arguments, fine. Blue book here.
My written arguments.
Blue book here. Spiral.
Yeah, blue book. More. First ఇచ్చిన ఇప్పుడు లాస్ట్ లో ఇచ్చింది జడ్జ్మెంట్స్ మేడం. దాంట్లో చూడండి రిటర్న్ ఆర్గ్యుమెంట్స్ అని రాసి ఉంటుంది ఫస్ట్ పేజ్. అది కాదండి, అది లోవర్. ఇవి రెండు చూడండి, ఫస్ట్ పేజ్ చూడండి. ఫస్ట్ పేజ్ లో రిటర్న్ ఆర్గ్యుమెంట్స్ బై మాధవ్. అది కాదు, అది లోవర్ కోర్ట్, అది ట్రయల్ కోర్ట్. తర్వాత నేను ఐ హావ్ ఇంటర్ప్రిటెడ్ వాట్ ఎవర్ ట్రయల్ కోర్ట్ ఆర్గ్యుమెంట్. అంత సన్నది లేదు మేడం. మేడం ఇంత దొడ్డుగా ఉంది ఇది ఇక్కడ. అది కూడా కాదు రిటర్న్ ఆర్గ్యుమెంట్స్. అది
రిటర్న్ ఆర్గ్యుమెంట్స్ ఫైల్ బై మిస్టర్ Mahadevan.
Yeah. The logic brought it
Before this court, not before the trial.
before this.
Yes. Which page you are referring? Anyway, we'll continue tomorrow. So tomorrow you are going to complete this, right?
I'll complete. I am already prepared. You will hand over citation. I will complete it.
Citations, procedural irregularities, paradox of it.
Where is A2? A2 to A6.
I'll tell you.
I'll tell you. One more important aspect, Mr. Madhav. In other deferred cases, penalty cases, we have appointed mitigator in Vivek Reddy's matter, Mr. Vivek Reddy's matter, Mr. Sudhanshu Rao matter. Because even Manoj reference is on altogether different point.
Yes.
So Supreme Court, after reference, passed 17 orders appointing mitigating circumstances, even before hearing the appeal itself. So on that you have to, because we want to take one view. In other two matters, we have already appointed with certain directions. So in this also, we want to appoint mitigators, irrespective of the result of the appeal. Because we want to take a uniform stand. So as per those 17 judgments, we have power suo motu to appoint mitigator even before hearing the appeal. That is the law.
Before the appeal, not after.
Before appeal itself. At any stage we can appoint. So that also please decide. We have decided to appoint mitigator. You have to give the mitigators names. You can also.
No, my lord, actually.
The people who are attached with project 39 capital A. That would study.
No. I have a clarification on this, my lord. After that,
Manoj.
By Justice Ravindra
Manoj
case. Manoj case, what they said, they did not touch the merits of the case.
Correct.
But they reduced, converted the death sentence into life sentence because there are 7 years are over after passing the death sentence. And these mitigating circumstances, referring to all the previous person case, Manoj case also, the judgment clearly said that it may be referred to a larger bench for adjudication.
Not for.
The reason is this mitigating circumstances aspect, because every court or every high court, different high courts may pass different orders. There is no fixed framework.
Sentencing policy.
Yes.
Not with regard to appointment of mitigator.
No, I am coming. Shall I open that one? I have that. In the operative part, it is clearly mentioned, I think, or not? Because what happens, my lord, what the judges said is that without a fixed framework, if this is allowed, this project is allowed.
Fixed framework with regard to?
With regard to conditions, what conditions are required?
What?
Because different courts may cause different orders and it may lead to multiplicity of litigations.
Conditions for?
Appreciating that mitigating circumstance.
Anyway, that we will hear you tomorrow. Even that also we will hear you tomorrow. So prima facie.
So automatic. Yeah. This is the, these are the before the operative part. They discussed all the sentence cases till today.
No, Mr. Madhav, we will do one thing. In another 5 minutes, my court officer will furnish you the order which we have passed in two artists. Please collect it and assist tomorrow better for me also.
In the writer, there is a clear conflict of opinions by two sets of three judges division benches on that subject. As noted before, this court in sentencing has taken into consideration the fairness afforded to a convict by a separate hearing as an important safeguard to uphold imposition of death sentence in the latest of the rape case by relying upon the recommendations of the 48 Law Commission report. It is also a fact that in all these cases where imposition of capital punishment is choice of sentence, aggravating circumstance would always be on record and would be a part of the prosecution's evidence, leading to conviction, whereas accused can scarcely be expected to place mitigating circumstances on the record for the reason that stage of doing it so is after conviction. After conviction. Then this places the convict at a hopeless disadvantage, tilting the case heavily against him. This court is of the opinion that it is necessary to have clarity in the matter to ensure a uniform approach to the question of granting real and meaningful opportunity, as opposed to a formal hearing in the accused or convict on the issue of sentence. Consequently, this court is of the view that a reference to a larger bench of 5 honorable judges is necessary for this purpose. Let this matter be placed before this honorable Chief Justice of India for appropriate orders in this regard.
Please read the reference point. Even we have extracted reference in our order.
It is there are 22. This court had adjourned the matter for submission of sentencing with directions being report from the probation officer, jail authorities, a trained psychiatrist, psychologist. This one?
No, point of reference. No, we will do one thing, Mr. Mantri. So we will give you the copy of one order.
Yeah.
I'll go through. And also to him, please go through and assist us tomorrow. అదే మనది గంగాధర్ దేశ్ ఒకటి ఇచ్చారు ఈవెన్ చంద్రశేఖర్ రెడ్డి కూడా ఒకటి వర్డ్ శ్రీ టి విష్ణువర్ధన్ రెడ్డి ల్యాండ్ స్పెషాలిటీ దిస్ NIA and Sri Appam Chandrasekhar, Land Council appearing for